been rejected, Honorable Mr. Justice, of placing on a lordship on an IA matter. That's why this case has been assigned with Justice Arun Kumar Rai.
So you go to the registry. You have to go to the registry for listing. I can't list it. Or you go to the Honorable Chief Justice for listing.
Honorable Chief Justice has already been assigned lordship. That's why I am mentioning.
अब आप इतने पुराने हो गए हम आपको प्रोसीजर तो नहीं सिखा सकते ना। आप रजिस्ट्री के पास जाइए, वो लोग अपना बेंच कॉन्स्टिट्यूट करेंगे, चीफ साहब से पूछकर तभी कुछ होगा। हाँ, यस।
From the listeners, 31 and 32 seeking accommodation for the
Please don't mention for adjournment. Yes.
I was mentioning for being taken up, Your Lordship. One matter is serial number 38 and 39. It's hearing matter, Your Lordship. WPL.
So you are for whom?
I am for the petitioner.
Who is for the other side?
Shresht Gautam is there who will be representing the same.
आपके नाम के पहले मिस्टर लगाना जरूरी है समझते?
Sorry.
Not required.
Sorry, Lordship.
31 and 32.
No, Lordship, 38 and 39.
You are for the petitioner.
Yes, Your Lordship. I am there saying.
What is the matter?
I have been dismissed. My service has been dismissed, Your Lordship, on the ground that I have suppressed one information from the attestation form, and on that ground, my service was dismissed. I was dismissed from the service, Your Lordship. That order is only under challenge.
Some criminal case against you.
Yes, Your Lordship. The criminal case was I have been acquitted in that criminal case.
Why a petition for amendment?
Not actually. There was due to misunderstanding, 2 matters has been filed, Your Lordship, and by the earlier order. The
call
earlier
Mr.
bench.
Shresht Gautam, we'll fix a time and date. We'll fix a date, right? Call him.
I will.
This is WPC matter of 2021. This petitioner is in possession due to which the respondent is. No, it is out of list.
From supplemented is Porter's Defect Item 1. Read filing number 12440 of 2024.
The matter it relates to arbitrary order that has been passed by APFC Jamshedpur.
The matter is still defective.
The matter is defective. Only one thing it has been.
Point out. You have to point out at the outset that it is a defective petition.
I have cured all the defects, but for one, they have asked for supplementary affidavit. But this is the minor.
Minor से नहीं होता है. Affidavit का defect हम लोग नहीं remove कर सकते.
So I have requested to ignore the. Because they have freezed the bank account and the enterprise it is suffering because the bank account has been freezed and a very arbitrary action has been taken by APFC. One pending matter is there before tribunal, but still they have ordered for fresh payment for a fresh period. So that is why we requested.
What is the nature of defect to be ignored? What is the defect to be ignored?
Defect instead of a partner, petitioner is written in the affidavit. In fact, the petitioner is partner, and partner can affidavit on behalf of other partners also. But they say that it should be written partner instead of petitioner. For that small thing, it is lying, and it would take another 10-12 days. So that is why we requested that.
Why 12 days? 12 days to remove the defect.
It takes, from read section, it will go to.
You file it today, we'll post it tomorrow. You file it today, you remove the defect today, we'll post it tomorrow by judicial order.
The petitioner, he is in Delhi.
So therefore, don't tell us that a High Court will take time to get your matter.
So it will be difficult. So that is why we have requested.
Where is the other side?
The respondent side is not present.
You have to call him, no? Because in a defective petition, how do we pass an order like this?
I will call the respondent right now, ma'am.
Call Mr. Priest. Call him at 1 o'clock.
For orders item 2, WPC 372 of 2019.
May permitted to withdraw this application.
WPC number 372 of 2019, the learned counsel for the parties are present. The learned counsel for the petitioner seeks permission to withdraw this petition. Counsel for the opposite party, any objection?
No.
Has no objection to the prayer for withdrawal. Accordingly, this petition is dismissed as withdrawn. Interim order, if any, stands vacated. Committed.
One IA is also pending.
I get closed.
सर साइन कर लीजिए
For admission item 3, WPC 102 of 2007.
Malas praying for not today as well as file is stressless since this is an old file malas. So I'll take the file from the petitioner's hand.
Prayer rejected.
Only one indulgence malas. It may be kept by tomorrow malas. I'll since this is an old file
No.
malas.
You just can't have adjournments like this. We spend time in reading files. You can't have adjournment like
I
this.
never do malas, but
कोई
malas
बात नहीं।
since file
पढ़
is
लीजिए,
stressless,
सेकंड हाफ में पढ़ लीजिए। नहीं करेंगे adjourn, पढ़ना ही है ना आपको,
malas.
पढ़िए। लीजिए इनको सेकंड कॉपी दे दीजिए तो फाइल का पूरा रिकॉर्ड दे दीजिए इनको पढ़ने। Come at the system. चलिए next question. मैटर रिमांड का ही बनता है, ज्यादा कुछ है नहीं।
Item 4, the WPF 4002 of 2019.
My lord, I have received instruction, my lord. The appeal shall lie before the industrial tribunal Ranchi.
इंडस्ट्रियल ट्रिब्यूनल एक्ट
It is functional and it has been constituted under Jharkhand Shops and Establishment Rules 2001.
against the order passed by the Labor Court.
Ji.
आइए 11 बजे।
Item 5, WPC 4048 of 2021.
My lord, in compliance of law, my lord, you file a counter affidavit.
Where is the petitioner?
Pardon me, my lord?
Now you have already stated that
Yes, we will
steps
require.
have been taken
Yes, and we require 100 days for the preparation of final judgment.
about. So their grievance will be redressed.
Yes,
That is why they are not interested.
entire thing, statement.
Are you there?
Yes.
Now they need 100 days to prepare the award. You will get the money.
Milord's one point that is to be, they have stated in the counter affidavit that since the publication, date of publication of the initial notice under section 11, they needed 100 days. The notice was published on 27/24. Already 150 days have passed
They
here.
will do it.
So
They'll do the needful. Don't worry
only
about it.
expedite.
Yes.
expedite.
They have said 100 days. We will say that you do the needful at the least.
100 days already passed, therefore I was in the same condition.
This affidavit was filed when?
File on, my
22,
lord.
12, 24.
But the notices are of 27/24, that's why. And in that paragraph number 10, they have specifically stated
Lapse
that
नहीं करेगा ना proceeding.
नहीं, एक साल के अंदर तो हो जाएगा तो नहीं करेगा।
कितना टाइम हम लोग ये तो 100 days
ओवर हो चुका है अक्टूबर में मिला।
अक्टूबर में नहीं अभी तो 2 12 को फाइल किए हैं तो भी 100 days कब खत्म हो रहा है?
फरवरी के अराउंड
February, my lord. Last.
December, January, right?
March first week.
By end of March first week. WPC number 4048 of 2021. The learned counsel for the parties are present. This petition has been filed for the following reading. the grievance of the petitioner in the writ petition appears to be that the petitioner has been deprived of the property of immovable property without following the procedure of law, and consequently no compensation has been paid to the petitioner. Pursuant to order dated 25/7/2024, an affidavit has been filed. A supplementary counter affidavit has been filed, wherein following statements have been made. Para 7 से लेकर 10 तक quote करें. The affidavit is dated 2/12/2024. The learned counsel for the petitioner submits that some time frame may be granted to complete the procedure, as much time has elapsed. Counsel for the respondent submits that, as per the affidavit, 100 days would be required, and from the date of the affidavit, the 100 days would expire tentatively in the first week of March. He submits that needful will be done at the earliest. Considering the aforesaid facts and circumstances, this court is not inclined to keep the present district petition pending. Suffice is to say that the respondents would abide by their statements made in the supplementary counter and do the needful within a period of latest by first week of March 24. The petitioner to cooperate. आपको कुछ फाइल वाइल करना होगा, डॉक्यूमेंट्स या कुछ
डॉक्यूमेंट्स वेरिफिकेशन के लिए ये लोग टाइम दिए थे 60 डेज का, वो भी एक्सपायर हो चुका है. ऑब्जेक्शंस एंड ऑल रेज करने का टाइम भी ओवर हो चुका है.
The petitioner to cooperate.
Cooperate.
Petition is accordingly disposed.
From daily list for final disposal, item 1, WPL 5599 of 2022.
In this case, I have gone through the judgment of DP Maheswari case, and
Let the tribunal decide the case, and then your right with regard to this
in
relief
addition
also.
to that, I have to submit one thing. As because this petition has been filed under Article 246, so that is a one petition, one IA has also been filed to convert the
No, it is WPL. It will come under WPL only. It is arising out of award passed by the.
See, then all the grievance which is raised in this petition.
The court will decide the case in accordance with law, and whatever grievance you have in this, you will have your right to agitate after the disposal of the.
At the time of the before passing a word.
नहीं ऐसा नहीं होता है. वो एक ऑर्डर होता है, उसके बाद वहाँ पर सेक्शन 11A में या जो भी है उस पर प्रोसीडिंग होता है, एंड देन
सेक्शन 11A का प्रोसीडिंग पेंडिंग है.
ठीक है ना. 11A का प्रोसीडिंग में आप पार्टिसिपेट करिए, अननेसेसरी आप यहाँ आ गए.
तो उसमें सारा चीज हम रेज कर रही है. हम
उसमें नहीं, उसमें जो 11A के अनुसार जो होता है,
हाँ, उनके परव्यू में जो है वो तो
एक बात सबसे पहले द डोमेस्टिक इंक्वायरी, इसमें फेयर एंड प्रॉपर बोला है कि अनफेयर बोला?
फेयर बोल दिया है.
फेयर बोला है ना. तो फिर उसके बाद मैनेजमेंट का वहाँ पे जो भी होगा 11A के तहत जो प्रोसीजर होगा वहाँ पे फॉलो.
And one another thing, the company has been amalgamated with the Tata.
ये सब कहानी तो है नहीं, आउटसाइड द रिकॉर्ड हम कुछ सुनते नहीं. WPL नंबर 5599 of 2022. Heard the learned counsel appearing on behalf of the petitioner and the state. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that by the impugned order, the domestic inquiry has been found to be fair and proper, and the matter was directed to be posted for further proceedings on 9/4/2020 for hearing in terms of Section 11, capital A of Industrial Disputes Act. The Learned Counsel has, pursuant to the Learned Counsel has the Learned Counsel submits that he has gone through the judgment passed by the Honorable Supreme Court in the case of D.P. Maheshwari versus Delhi Administration within bracket 1983 bracket post 4 SCC 293, and he submits that appropriate order may be passed so that the learned court shall consider the matter in terms of Section 11, capital A of Industrial Disputes Act, and the points raised in the present petition be kept open. Right?
Timeline.
2020 से तो कुछ ही क्या ही timeline है?
2012 से ये
He has
केस है.
also submitted that as of now the matter is still pending before the Learned Labour Court. Correct? Pending है?
हाँ, ये एकदम.
Pending है? The Learned Counsel appearing on behalf of the state has also submitted that the present petition at interlocutory stages is not maintainable. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, and upon going through the judgment passed by the Honorable Supreme Court in the case of D.P. Maheshwari Sutta, this court finds that at the preliminary/interlocutory stage with regard to legality and validity of the domestic inquiry, the present petition is not fit to be entertained. From the perusal of the impugned order, this court finds that the court had already fixed the matter for adjudication in terms of Section 11, capital A of the Industrial Disputes Act. It is sufficient to observe that the challenge to the impugned order holding the domestic inquiry as fair and proper will be kept open, and upon final adjudication by the learned court, if the petitioner still continues to be aggrieved by the final order, it will be open to the petitioner to raise the grievance in connection with the finding that the domestic inquiry was held to be fair. At this, the counsel for the petitioner has submitted that appropriate order may be passed so that the adjudication in terms of Section 11A is expedited. The matter is pending before the learned presiding officer, Labour Court, Jamshedpur since 2012. Suffices to observe that the learned court shall pass appropriate orders and shall take appropriate steps for expeditious disposal of the matter without giving unnecessary adjournments to the respective parties. Let this order be communicated. This petition is disposed of. आइए closed. आपका मैटर बोलते ट्रिब्यूनल में अपील लाई करते हैं. वो जो है ना वो दूसरा ही चीज है जो अपील हम देख रहे थे आज सुबह. दैट इज अ सेपरेट थिंग. the labor court gets jurisdiction by virtue of a notification issued by the state. और लेबर कोर्ट के ऑर्डर के अगेंस्ट में ये एडमिनिस्ट्रेटिव एएनसी अपील थोड़ी सुने, isn't it? ट्रिब्यूनल में चलेगी ऑर्डर. Are you there in this case?
Yes, ma'am.
WPL 4002?
Yes.
WPL number 4002 of 2019. Heard the learned counsel appearing on behalf of the parties. This writ petition has been filed for the following relief. At the outset, the learned counsel appearing on behalf of the respondents have submitted that petitioner has alternative remedy of appeal before the appellate tribunal, and therefore the writ petition may not be entertained. He has also submitted that there are disputed questions of facts involved in this case. Considering the submissions, at this counsel for the petitioner submits that liberty be reserved with the petitioner to avail the alternative remedy. After hearing the counsel for the parties and considering their posted submissions, this court is not inclined to entertain this writ petition at this stage. However, it will be open to the petitioner to avail the remedy of appeal before the learned tribunal. Alternative remedy of appeal within a period of 1 month from today.
Yes.
Under section 26(7).
नहीं 26(7) में नहीं है ये लेबर कोर्ट का ऑर्डर है, इसके अगेंस्ट में एपीलेट ट्रिब्यूनल उसका अलग ही हायरार्की है, उसका अलग ही हायरार्की है. 7 रूल 7 वाला there is a notification.
I have also preferred appeal before the
ये शॉप्स एंड एस्टैब्लिशमेंट का अपील इंडस्ट्रियल ट्रिब्यूनल में होता है.
From trade list for orders item 2, the LPC 4385 of 2019.
In this case, Milord, if I had ordered it at 27/2024, that is order number 8, I was directed, Milord, to file notice to respondent number 7. Respondent number 7 has
DC
appeared.
has been, respondent number 7 has appeared.
He is dead. Therefore, his son.
I filed an IA for substitution.
IA number?
That is 10021 of 2024. In para 2, I have stated that respondent number 7.
Where is the death certificate?
Death certificate is annexed as IA1, IA connection 1. That is in page 6.
When did he die?
He passed on 10th of
10/10/2021.
October 2021.
And you are the only son, or there are other individuals?
There's a wife also. And
All of them have filed wakalatnama. What are the details of the legal case?
in para 2 litigation, I have stated Binda Devi, aged about 53 years. She is the wife of late Jagannath.
And the son. Any objection? Petitioner, any objection?
No, Milord, that may be substituted. I have no.
आपको objection है?
No, no.
आपको कोई objection है?
What the
But
order
the
was?
procedure is wrong. The respondent who is already dead, he cannot file substance. He could have filed order 1 rule 10 petition.
ना
That is the
क्या
process.
करना है?
That is the
Petition में
procedure.
वकालतनामा के साथ फाइल
जी,
करना है और क्या ही करना है?
नहीं, उतना टेक्निकलिटीज में जोड़ क्या है इस सब केस में.
देखिए उनका काम है वो पॉइंट आउट किए क्योंकि सब्स्टिट्यूशन तो टेक्निकली आपको करना था, बट ही इज जस्ट पॉइंटिंग आउट द प्रोसीजर.
He is right, but since here they have appeared, I will wakalatnama.
आई नंबर 10021 of 2024. This interlocutory application has been filed on behalf of the son and wife of respondent number 7, annexing the copy of death certificate of respondent number 7, who is said to have expired on 10/10/2021. it has been submitted that the Wakalatnama has also been filed along with the interlocutory application. Learned Counsel for the petitioner submits that he has no objection if the respondent number 7 is accordingly substituted. आप किसकी तरफ से हैं?
Respondent number 6.
The counsel for the respondent number 6 has submitted that technically it was the petitioner who had to take a step. After hearing the learned counsel for the parties and considering the fact that respondent number 7, that the death certificate of respondent number 7 has been placed on record, who has expired during the pendency of this case, and his legal heirs and successors have filed the interlocutory application along with the Wakalatnama. This court is of the view that the respondent number 7 be substituted. Accordingly, IA number 10021 of 2021 is hereby allowed. The counsel who has filed Wakalatnama on behalf of legal heirs and successors of respondent number 7 is directed to carry out necessary corrections in the cost item in ready during the course of the project. आगे बताइए।
आगे
आइए ना।
काउंटर देंगे कि नहीं देंगे?
आपको कुछ फाइल करना है काउंटर? कितना टाइम चाहिए? Posed this case on 18th of December 2024 in the supplementary cause list. In the meantime, the substituted respondent number 7 to 5 counter.
If my lord fixes any date, then my lord, I may be given time to file his wife.
अभी तो आ जाएगा तब ना,
हाँ।
इसीलिए 18 तारीख को बैठे। उस दिन आप टाइम मांगेंगे हम दे देंगे। तो पता है 3 बार बिना डेट हुए काउंटर आता है झारखंड हाई कोर्ट में। आ जाएगा सर, आ जाएगा, हम आपको टाइम दे देंगे।
Item 3, WPC 3864 of 2021.
Pursuant to order dated 12 February 2022, notices were issued to the respondent 5, who is resident of Ranchi, in both processes. The office note says that he was shown to be out of station. So it could not be served, the undelivered copy is there. So it may I pray before Lordship?
अनडेलीवर्ड कॉपी कहाँ है? कहाँ नहीं?
है लिखा हुआ ये अपीयर कर रहा है
I have instruction to appear from behalf of respondent number.
वकालतनामा आया है?
Yes, my lord, we have to file.
तो करिए ना।
We need time.
सम टाइम मतलब करिए आज। वकालतनामा साइन किया हुआ मिला है ना आपको? उसके लिए आपको किसी का जरूरत नहीं है फाइल के लिए। आगे क्या है बताइए? काउंटर फाइल करना। Tell us what is it?
This is not the order impugned in Annexure 5 page 40, whereby the respondent number 3 cancelled the Jamabandi created in favor of the petitioner and directed the imitation of this minute. That is the respondent number 3 in the capacity of appellate order. That is the final order. Therefore, it is maintained.
Okay, WPC number 3864 of 2021. Mr. नाम बताइए अपना प्लीज।
शैलेश कुमार सिंह, AC to Mr. Rahul.
लिख के दीजिए। Mr. Shailesh Kumar Singh, AC to Mr. Rahul Kumar, Advocate, undertakes to file wakalatnama on behalf of respondent number 5 during the course of the day. इनसे लेकर फाइल ले लेंगे। कितना टाइम चाहिए काउंटर फाइल करने में? 2 weeks. At the prayer of the learned counsel, time till 17th of December is granted to file counter affidavit. Post on 18th in the supplementary.
I'll ask.
Mr. Rahul Kumar के साथ दोनों का appearance record है ना?
Subject to minutes, the copy is there.
Unserved copy is
Unserved
on the
copy is
record.
there on record.
Okay, the unserved copy to respondent number 5
5 minutes.
is directed, is permitted, is directed to be given to Mr. Rahul Kumar. वकालतनामा फाइल कर दीजिए.
हाँ बस.
By the office.
For admission, item 4, WBC 5601 of 2009.
Lordship permit one. Only one password for one cases, one judgment. I just want to cite.
Item 5, WPL 598. Item 5, WPL 5938 of 2014.
Where is the respondent?
Yesterday we filed a synopsis of arguments.
But where is the respondent?
We have paid the cost.
I'm looking for the respondent. बुलाइए Mr. Sushant Kumar. Let him come. आज 2:15 में कोई मैटर रखे हैं क्या हम लोग? 2:15 में आइए.
अभी पास हुआ नहीं पता है.
क्या मैटर? हाँ, ठीक है कोई बात नहीं. ये भी हो सकता है. ज़्यादा. वो आ गए सुशांत कुमार. चलिए. Ready? Yes.
The award is at annexure 4. Page 109.
The red pencil here. The pencils of sharpened. Yes.
The terms of reference have been quoted in paragraph 1. Annexure A middle portion. Whether the management Gammon India Limited Panandu Workshops Ranchi is justified in not giving work to its workmen so and so and getting done by outside workers, if not, what relief the workmen are entitled to. This is the terms of reference. The background facts are that this company had two separate industrial establishments, one at Birsa Chowk and the other at Panandu. They are separated by a distance of about 18 to 20 kilometers, which is come in the evidence. The Birsa Chowk unit was in a rented establishment. It was closed down on 17/2/2003. It had 41 employees. The
17 to
2003.
41 employees.
41 employees.
Yes.
Closure was undertaken. The closure was accepted by all except these 15 persons whose names are recorded in the terms of reference. They refused. They had challenged the closure, stating that there is already a conciliation proceeding pending, and therefore they straight away filed a writ petition in the High Court stating that there is infringement of section 33.
Writ number?
That writ number is WPS 2038 of 2003, which is annexure 3, page 91. Annexure 3, page 19.
That's right.
The operative portion says, considering the facts and circumstances of this case, this writ application is being disposed of by
That's right. He was directed.
He was directed, he passed an order, which is the next page, 92, and he holds that there is no violation of 33 and he does not interfere with the action.
This is dated 9/9.
This is dated 9/9/2009.
2009. Where is the finding?
The findings are second page 93. After noticing the High Court's order, the last 2-3 paragraphs. So this order has become final. This is undisputed that this order was not challenged by them subsequently.
So there is. He held that there is no violation of section 33.
There is no violation of section 33 in closing the establishment at Birsa Chowk. So therefore the closure was not in dispute. They had raised a grievance regarding closure being in contravention of the provisions of law, including section 33.
But that is not the terms of reference.
But that is not the term. But after that, they got the terms of reference that Palandu establishment is not giving us work and taking work from outside workers.
There was a modification of terms of reference.
No, this is the only terms of reference. 2009, this order comes, closure matter ends.
Okay.
Then in 2011, they go and get that dispute referred that Palandu is taking work from outside workers and not giving
And
us
this
work.
is regarding Birsa Chowk.
And this is regarding Birsa Chowk. Everybody was offered, including them. The checks were also dispatched.
Palandu is taking work from outside.
Outside workers, that is the terms of reference, and not giving them work.
It is specifically in connection with Palandu.
This is specifically in connection with Palandu. The terms of reference. Annexure 4, page 109.
So how are they connected with Palandu?
They are not connected. They were working in Birsa Chowk admittedly. Now they have set up a case here.
Are they two distinct establishments?
We have stated that these are two distinct industrial establishments with separate registrations. And after
Registration under?
Separate registrations under Factories Act. There was a question whether certified standing orders are there for. They have stated that there was certified standing orders in only one of the establishments, not the other, because there was no requirement to take certified.
In case there is no certified standing order, it goes by the standard format. Of
Correct.
certified. That is the law, I think.
Yes, that is the law. Model standing orders will apply.
Model, yes.
So, but the question is that they have already, the closure was never referred, the validity of the closure.
Is there any finding on the closure?
There is a finding that it is in fact not closure, it is proposed closure, it is actually a transfer of undertaking. This is the finding which is beyond the terms of reference. Secondly, it is retrenchment.
That is beyond the terms of reference.
Then how this can sustain, and this order on the face of it has become final? The closure is final? So what relief can you be granted to me?
But there is a they have violated provisions of section 25F and 25N of the ID Act.
That is not the terms of reference.
That is not.
That is not the terms of reference.
Terms of references with regards to Palandu.
Yes. That is not the terms of reference. आपका कितना पैसा, इनका कितना पैसा बाकी है? Closure.
They have taken 17B all along. This case has remained pending. They'll get the closure compensation.
Closure compensation कितना है इनका?
इनका तो यहाँ पे तो नहीं है.
सबको दिए है ना?
Average हाँ सबको दिए. Exhibit F101 में एक model standard by way of format लगाए थे. Depending on their total final length of service, 180,000 or something, or 15, it has to be computed.
मत लीजिए।
linear leadership, but इसमें यही 25F
25F, that is not the
that
terms
is
of
not the
reference.
terms of reference.
Is there any finding regarding 25F, etc.?
Yes, but
That
it
is
is
not the
beyond.
terms of reference.
That is also beyond the terms of reference.
The
Show
finding
me
is in
two things. One is regarding the closure. What is the finding here?
Paragraph 17.
Yes.
Both findings are there in the paragraph 17 itself. Page 120.
Yes.
From perusal of the evidence of all the witnesses of both the sides, all the exhibits produced by both the parties, and from perusal of the observation of honorable courts and hearing the submission of the learned lawyer of both sides, it appears that the management did not give any opportunity to hear the applicants, which was total violation of provision of section 25N and 25F of the ID Act. There is no hearing. It also appears that all the workmen were employed on regular basis and were getting wages on monthly basis based on statement arrived at between the management and union from time to time. It also appears that on the management's act of not continuing the service at Palandu workshop establishment is illegal and unjustified. From perusal of the materials available on the record, it also appears that some workers who were employed at Birsa Chowk establishment by the management, they were not given service by the management in Palandu workshop. It also appears that the Birsa Chowk establishment was not closure, but it was shifting at Palandu establishment. Therefore, for the end of natural justice for
And
the
it
workmen.
also says that management's act of not continuing the service as Palandu. That is not the reference.
That is not the reference. And closure was never in dispute.
आपको पैसा चाहिए तो बोलिए यहीं से ऑर्डर करेंगे, नहीं तो अपना रियलाइज करिएगा ध्यान से। बताइए क्या
Instruction
इंस्ट्रक्शन क्या लेना है इसमें? पूछिए, जाके पूछ कराइए।
The three judgments I have given in the compilation. 25H, there is a provision of giving employment, but that is applicable only in case of retrenched workers. Maruti Udyog case, which is at
Not
flag B.
required. It is absolutely express beyond.
Express I, but only for the purpose of law. If
Only.
if had it after closure, you can't take compensation and
In fact,
claim
25F
employment.
also may not apply after closure.
Yes.
Will it apply?
No, it will not apply.
Anyways, आप पूछ कराइए, 5 मिनट के अंदर आइए। लेना है तो आप कर देंगे ना पेमेंट तुरंत। इनका अगर जो भी ड्यूज होगा as per your because they have not taken compensation.
They have, I think, they have
If not taken, you
So
find
these
out.
15 people,
You find
this
it
case
out.
will be disposed of. With time-bound direction, they'll release the.
अभी जा रहे 5 मिनट लौट के आइए। Next is call. Yes, both of you are here. Ready? No, I don't know. You can fix the date only with your consent.
Yes, sir, any date. Any date. Apart from 17, 18th, any date.
There was a misrepresentation
Yes, sir. Admitted.
with regard criminal case.
Yes, sir. There is one other issue, let's say they have filed 2 appeals, 2 writ applications against the same very court.
For that purpose, Your Lordship, it was earlier tagged by the order of this honorable court. Both the matters were tagged together, and therefore it is coming in that.
You want to.
Not much, but I'll be pointing it out to the honorable court. Your Lordship,
What
that
I need to say is that you have already pointed it out. Now, arising out of the same impugned order,
Yes, sir.
so she should retain the previous one.
And for that
But in the
purpose, Your
previous one,
Lordship,
I'm not appearing. Your Lordship. In the previous one,
for
Mr.
that
GM
purpose, I
Mishra.
have filed in IA, Your Lordship. Both the matters are similar because certain
Similar
facts.
or
Same, Your Lordship,
same
from
order.
same the impugned
Same
order. So,
you have filed any petition for withdrawal of either of the 2 cases?
no, Your Lordship, not withdrawal because from the earlier order it was tagged along with, and the court was of the view that I will hear out because the same is both are arising from the same impugned order. Therefore, I have not filed any withdrawal application. Your Lordship.
In the preceding matter, Your Lordship,
You
I'm
come
not
in the second half. Either of 2 cases, one will be retained, and so far as the other is concerned, will be retained.
then the second one may retain, Your Lordship. First one may
First
not
one
be.
means?
For the reason, first one, serial number 38. For the reason that in the second one, certain documents are also annexed with the counter, Your Lordship, standing order and all are there annexed with the rejoinder of mine, which is not there in the first one.
Technically, in law, the previous one
Yes,
should
Your Lordship.
stand.
Therefore, I was just pressing
The
that.
previous writ petition should stand,
Yes,
not the
Yes.
subsequent.
but I am not appearing in those matters. Neither
No.
is she nor am I.
She's also not appealing.
No, but the council has stated, asked for
I
appearing
don't
in-
know. You call the council. It can't be like this. It can't be like this. We can't do it in that.
in the second half.
हाँ, you come with both the council should be
Yes,
there.
yes,
ये थोड़ी है कि दूसरा council फाइल कर देगा.
नहीं नहीं मैं दोनों को ही मैं चाह रही थी कि साथ में आकर सुनवाई.
ना आप बुलाइए उनको, ऐसे नहीं होता है.
जी. At 2:50
प्रोसीजर है. एक आदमी केस फाइल किए हैं. जो पुराना केस फाइल होगा रिटेन वही होगा. सब्सिक्वेंट वाला नहीं हो सकता. अगर रिकॉर्ड मंगाना होगा तो मंगाएंगे, चाहे सप्लीमेंट्री होगा तो होगा. और आपको भी वकालतनामा फाइल करना होगा.
उसमें हम नहीं हैं उस पे.
आप कर लीजिएगा.
GM Mishra sir is appearing Lordship on behalf of Steel Authority Lordship. I cannot appear simultaneously with him. He's already there, so I cannot take a.
उनको भी बोलिए ऑनलाइन ज्वाइन करने से. दोनों में से एक रिट पिटीशन हम लोग रिटेन करेंगे और जो उनके एडवोकेट ऑन रिकॉर्ड है उनको भी लेकर आएंगे. तभी होगा, उसके बिना नहीं होगा.
2:30.
2:30 व्हाट है?
Item 6 WBC 2861 of 2015.
Creating this litigation matter for crossing Annexure 9 matter. The order passed by the Deputy Commissioner. What has happened in this case matter, the Commissioner has moved before the Solemn Court by filing a petition matter, whereby matter
Annexure 9 is page 51. That is not Annexure 9, इस पर 7 दिख रहा है, इसीलिए पूछ रहे. कौन सा डेट का ऑर्डर है?
Page 57 है. भाई 10/1/2013.
Annexure 7 है.
Annexure 7 is the order passed by the Solemn Court.
इसमें आपका Annexure मार्किंग ठीक नहीं है. Anyways, वो फिर से यहाँ पे 7 ही दिख रहा है, 2 बार 7. ठीक.
Page 57 पे.
पहले पेज 46 पढ़ी. क्या डायरेक्शन हुआ था हाईकोर्ट की रिप्रेजेंटेशन डिस्पोजल का?
रिप्रेजेंटेशन इसमें अगर पढ़ देता है लास्ट से दो पैरा में. In view of this, the writ petition is disposed of with direction to the respondents to examine the representation and pass appropriate order in accordance with law after giving an opportunity of hearing. It is also directed that the rate receipt which used to be issued in favor of the petitioner shall be continued to be issued in accordance with law. The petitioner is also directed to make fresh representation, including copy of previous representation. This exercise shall be carried out such and such date, and this was disposed of. Now, my lord, they have passed Annexure 9, page 57 और जो तीसरा पारा हम पढ़ रहे हैं, उक्त के आलोक में अंचल अधिकारी कटकम सांझी से प्रतिवेदित किया गया है कि अंचल अधिकारी कटकम सांझी ने अपने पत्रांक 252 दिनांक 6/6/2012 में प्रतिवेदित किया गया है कि प्रतिवेदित विवरण गैर मजरूबा खास खाते की है और पंची 2 के अनुसार वर्ष 1957-58 में से 78 तक सरकारी लगान रसीद निर्गत है. पंजी 2 के अनुसार 4H वाद संख्या 14/1953 But this is important because in para 17 we have stated that we have perused the entire record of this 4H and my land is not involved. This is averment in para 17 of my petition. Now what happened?
Where is the final order passed in this 4H?
This is my case कि 4H के प्रोसीडिंग में मेरा जमीन नहीं.
अरे भाई कहाँ है वो प्रोसीडिंग?
वो प्रोसीडिंग हाँ वही बात बोल रहा हूँ.
आपका जमीन का क्या डिस्क्रिप्शन?
हम मेरा जमीन जमीन का डिस्क्रिप्शन.
चौथी डिस्क्रिप्शन सब बताइए. खाता नंबर, प्लॉट नंबर, रिट पिटीशन से.
हाँ रिट पिटीशन से बता रहे हैं.
खाता प्लॉट सब बताइए.
मेरा है हजूर तो जो प्लॉट नंबर है मेरा 1046 अंडर खाता नंबर 30.
देखिए एक सेकंड. You are claiming this property through हुकुमनामा.
Yes. हुकुमनामा and continuous rent receipt.
हुकुमनामा का क्या डेट है?
1945.
1945. यहाँ पे हाथ से इंसर्शन है जिसमें कोई लाल दाग भी नहीं है, इसलिए पूछ रहे हैं हम आपसे।
हाँ 45 हो गया, गलत था 93 45 का।
ठीक है, प्लॉट नंबर है 1046 398।
By the हुकुमनामा several plots were given.
सेवरल से नहीं, हमको सिर्फ आपसे मतलब।
हाँ तो नहीं, हम ही को मिला था जो टोटल 30 एकड़ मिला था, लेकिन सब्सिक्वेंटली बाद में मेरा कुछ जमीन चला गया, कुछ फॉरेस्ट डिपार्टमेंट में चला गया, कुछ पीएचडी में चला गया। फाइनली हमारे नाम पर अभी जो था 4.18 एकर्स का कटता था रसीद, जो कि प्लॉट नंबर 1046 अंडर खाता नंबर 30। ये था हजूर हमारा केस।
प्लॉट नंबर
1046 खाता नंबर 30 एरिया 4.18 acres.
खाता नंबर 30 एरिया
4.18 acres.
4.18 acres. This plot number 1046 is not included in this case.
In this case, it has not been included. I have stated
wait second, 4H case number 14 of 1953-54. This khata number is not included.
Not included. This khata number included. Plot. This khata plot is not included. This I have stated in para 17 of my writ petition. Now what happened, my lord?
No, you have said khata number 30 and plot number 1046.
Area 4.18 acres.
We are not concerned about the area, but this particular.
This has not been included.
This plot number 1046 and khata number 30 is not included.
Not included. Now what happened, my lord? Thereafter.
नहीं दिखाइए कहाँ है वो?
हम वही दिखा रहे हैं। एक एक करके हम कल फैक्ट बता दे रहे हैं, थोड़ा सा 1 मिनट समझ लेंगे। उसके बाद जरूरी काउंटर एफिडेविट फाइल किया, इन्होंने भाई सेम स्टैंड लिया कि ये जो है खाता प्लॉट उसमें है। Then my lord, I filed reply to the petitioner's reply to the counter affidavit on 8/10/2018. Therein, my lord, I have brought the entire 4H proceeding, copy of which was given under RTI Act to me.
कहाँ है आपका entire 4H proceeding?
हाँ, उससे 8/10/2018 को फाइल किया है। मेरा है petitioner's reply to the counter affidavit filed on behalf of the respondents. Got it.
इसमें प्रॉपर्टी का डिस्क्रिप्शन कहाँ पर?
इसमें प्रॉपर्टी का डिस्क्रिप्शन है ही नहीं, खाली जो हमको जितना प्रोवाइड किया गया है इसमें कहीं नहीं है।
इसमें जो इतने सारे डॉक्यूमेंट्स रेफर्ड हैं वो कहाँ हैं? इसमें बहुत सारे डॉक्यूमेंट्स रेफर्ड हैं। सूट का जिक्र है, डॉक्यूमेंट्स का जिक्र है, तो क्या ही
इसमें हजूर अगर हमारा जमीन इन्वॉल्व होता तो हम भी पार्टी होते।
नहीं, ऐसा नहीं है ना। अब आप एनक्रोचर हैं कि थर्ड पार्टी हैं कि क्या है, क्योंकि आप यू आर क्लेमिंग ऑन द बेसिस ऑफ ए सादा हुक्मनामा which is not even followed by a rent receipt immediately.
No, it is being followed by the rent
45 का rent receipt है आपके पास?
मुझे rent receipt तो लगा है हमको
45 का rent receipt
45
1945
हम कब का लगा देख लेते हैं। लेकिन इनका जो कहना है, मेरा जो कहना है,
आप ये इस तरह से नहीं हो सकता है।
आप अपना टाइटल प्लेस कर लेते हैं।
गेट योर टाइटल डिक्लेयर। टाइटल डिक्लेयर
नहीं हजूर, हम जो कहना चाह रहे हैं हम उस पर टाइटल पे भी हम चले जाएंगे। मेरा दूसरा चीज कहना है, आफ्टर फाइलिंग ऑफ दिस काउंटर एफिडेविट, दिस ऑनरेबल कोर्ट हैज पास्ड द ऑर्डर माय लॉर्ड ऑन 10/1/2019। इफ माय लॉर्ड में काइंडली से I am reading, my lord. Mr. Rajiv Ranjan Tiwari, London Counsel for the petitioner, has submitted that the impugned order dated 10/1/2013 seems to be on the basis of case number 14 of such and such, in which the Jamabandi was cancelled, but the land of petitioner for which they have prayed for acceptance of cess and rent and issuance of rent receipt does not come within the land, which forms subject matter of case number so and so. London Counsel has brought the said order on record in his reply with the counter affidavit. However, no reply to the aforesaid contention raised by the learned counsel for the petitioner.
Therefore, I want to know from that order, which all are the property which is involved.
This is my मेरा कहना है.
So therefore उसमें
हमारा
उस प्रॉपर्टी में क्या है क्या नहीं है, कौन सा प्रॉपर्टी है, नोटिस किसको इशू हुआ था, अल्टीमेटली कौन कौन लोग अपीयर हुए, ये सारी चीजें कहाँ से ही हो जाएगा. और आप यू आर क्लेमिंग द प्रॉपर्टी ऑन द बेसिस ऑफ हुकुमनामा, राइट, ऑफ द ईयर 1945. Okay, and the first earliest rent receipt which you have is after 1946.
1946 वो तो जब भी होगा.
नहीं, ऐसा दोनों में बहुत फर्क है ना.
45 में तो हजूर स्टेट रेंट रिसीट देगा नहीं.
इसीलिए आपका ये हुकुमनामा का जो कहानी है ना.
हाँ तो BLR एक्ट आया हजूर 1950 में, उसके बाद ही ना
हुकुमनामा पर तो रीट कोर्ट नहीं ना डिसाइड करेगा.
हमारा रीट कोर्ट डिसाइड. हजूर मेरा कहना है कि आप मेरा क्लेम सिर्फ और सिर्फ ये कहते हुए रिजेक्ट कर दिया गया कि आपका नाम उस किताब में है. हम इतने तो कह रहे हैं कि उस किताब में मेरा नाम नहीं है. फिर हजूर ने ये आदेश पारित किया, उसके बाद फिर हजूर ये काउंटर एफिडेविट फाइल किया. हम कह रहे हैं हजूर उस किताब का उपन्ना तो दिखा दे, हम सूट में चले जाएंगे, हम कहीं और चले जाएंगे.
Say that the entire particular case of 4H was relating to the
Ramgarh Raj.
And you have also taken hukumnama from Ramgarh Raj.
He was the Raja at that time.
He was the Raja.
Okay, madam.
This is what their case is.
मेरा सिंपल सा केस है. जो हजूर ने ये आदेश पारित किया, फिर ही काउंटर एफिडेविट फाइल किया, अगेन सेइंग द सेम थिंग. नाउ माय लॉर्ड्स, thereafter this honorable court has passed the order on 8/8/2024 for filing counter affidavit. तो उस वक्त हम हजूर के सामने बोले थे कि हजूर कम से कम कोई प्रूफ तो दिखा दे कि मेरा कहीं नाम है. रिकॉर्ड इनके पास
नाम नहीं होगा, आपके प्रॉपर्टी का नाम.
मेरा प्रॉपर्टी का ही नाम हजूर. हम कहाँ बोल रहे हैं, इस प्रोसीडिंग में हमको दिखा दे मेरा प्रॉपर्टी का नाम है. आई एम आउट ऑफ द कोर्ट. खाली बोलने से तो नहीं, हम कागज ले आए हैं, रिकॉर्ड है, किताब में मेरा नाम है तो दिखा दे. हम तो इतना ही बोल रहे हैं, हम रीट कोर्ट के सामने और कुछ तो मांग नहीं रहे.
आपके पास क्या है?
हम लोग का कहना है कि इनका जो सादा हुकुमनामा है दैट इज फोर्ज्ड, और जो
फोर्जरी का एलिगेशन लगाए.
वो लास्ट काउंटर एफिडेविट, उसके पहले 4-3 काउंटर दिए. अभी कह रहे कि हमरा सब कागज
में किए चाहे कभी भी किए.
मेरा कहना है
कहां है बताइए.
पैरा 9
of the counter affidavit.
बहुत लिखे हैं.
Of the counter affidavit.
Yes, counter affidavit dated 27/11/24.
Para number
9.
इसको हम रीट में कैसे डिसाइड करेंगे?
हमारा तो हजूर हम कहाँ कुछ हजूर यहाँ कोई डिस्प्यूट नहीं है. वो सिंपल सा कहते हैं कि मेरा नाम चूंकि उस केस में है तो हमको रेंट रिसीट नहीं इशू होना चाहिए. हम कहते हैं मेरा नाम उस केस में नहीं.
इस तरह का डिस्प्यूट, लैंड डिस्प्यूट रीट पे मत डिसाइड.
हजूर उसका डिस्प्यूट नहीं कर रहे.
आप जाइए अपना सूट फाइल करिए.
तो हजूर इनके खाली कहने से ही होल्ड हो जाएगा कि मेरा नाम उसमें है. हम खाली इतने से
रीट तो एफिडेविट पर ही ना डिसाइड होता है.
हम तो ओरिजिनल डॉक्यूमेंट ले आए हैं.
यहाँ पर हम डॉक्यूमेंट नहीं पेश करेंगे. आपका जो ये हुकुमनामा है ना, ये हमसे पढ़ा भी नहीं जा रहा.
नहीं हुकुमनामा
टाइप कॉपी आप कैसे बनाए हैं हमको खुद ही नहीं पता.
हम हुकुमनामा की बात नहीं कर रहे हैं, हम बात कर रहे हैं.
ऐसा नहीं हो सकता. आपका ये रेंट रिसीट, इस तरह के डॉक्यूमेंट्स हम लोग पढ़ नहीं पाते हैं. आप लोग टाइप कॉपी फाइल कर देते हैं, सर्टिफाइड टू बी ट्रू, जो हम लोग को समझ नहीं आता है.
हजूर सरकार ने दिया है, सब तो इन्हीं के पास है. लास्ट में कहते रिकॉर्ड नहीं है.
WPC number 2861 of 2015. Heard the learned counsel appearing on behalf of the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner had filed a writ petition earlier, being WPC number 6763 of 2011. It was disposed of on 9/4/2012. He submits that at that point of time, the grievance of the petitioner was that the respondents were not issuing rent receipt, and subsequent to the year 1997-98, and they had filed an application for cutting of sakua tree standing on the Rayati land. He submits that the direction was issued to the petitioner to file a fresh representation, and the representation was to be disposed of by the respondent number 1 in the petition. The representation has been disposed of by order contained in memo number 95 dated 16/1/2013. He submits that, as which is included in the present proceedings, he submits that as per the said order, the authority has refused to issue the rent receipt by observing that the property is a part of proceeding under 4H, being case number 14 of 1953-54. And the entries made in Register 2 were directed to be deleted. The Learned Counsel submits that the order passed under section in the aforesaid case number 14 of 1953-54 has been annexed along with the affidavit filed by the petitioner dated 14/10/2018, but the property of the petitioner with which the petitioner is concerned, that is plot number 1046, khata number 30, area 4.18 acres, does not find place in that order, and therefore the interim order is to be quashed and set aside. The Learned Counsel has also referred to order dated 10/1/2019, wherein the respondents were directed time to file specific affidavit with respect to the assertion made by the petitioner.
And my lord, 8/8/2024.
The Learned Counsel, appearing on behalf of the state while opposing the prayer, had submitted that an affidavit dated 27/11/2014 has been filed alleging that the petitioner is claiming the property on the basis of forged and antedated hukumnama and other related documents, and it has also been asserted that the name has been entered in Zamindari Register 2 in collusion with Deed and Karamchari in the year 1957. It has also been asserted that almost all Gair Majurba Khas Bakas Zirat land of Ramgarh Raja, except which were settled before 1946 through legal documents, were subject matter of the case number 14 of 1953-54 under section 4H of Bihar Land Reforms Act 1950. And the additional collector, by his order dated 29/6/1976, annulled all the transfers made in schedules to the state order settled after 1st of January 1946.
never been challenged by the opponent.
The learned counsel submits that the order passed, the order dated 29/6/76 was never challenged. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the petitioner is claiming property through Sada Hukumnama and which is the oldest rent receipt placed on record. And there are serious allegations made in the affidavit dated 27/11/2024. This court is of the view that such disputed questions of right, title, interest, possession, etc. with respect to EU property cannot be decided under the jurisdiction. So far as the order dated order passed by Additional Collector Hazaribagh in case number 14 of 1953-54 is concerned, the order itself does not refer to any property, any particular description of property. However, there are annexures to the said order marked as schedule A, B, C, D, E, F, G, H, I and J, which has not been placed on record. Just a moment. Wait a second, please disturb me. Otherwise also on the face of the allegations made, such allegations cannot be adjudicated through the jurisdiction. Accordingly, this court is not inclined to grant the relief as paid for by the petitioner in this writ petition. However, dismissal of this writ petition will not be however, it will be open to the petitioner to get her right, title, interest, possession, etc. declared through a competent court of civil jurisdiction. And this order will have no bearing in the matter.
एक चीज है, उस ऑर्डर में हम पार्टी नहीं है.
Next.
Item 7 WPC 4996 of 2015.
You have been able to find out?
उसमें सिर्फ अगर आज इंटेलिजेंस
नहीं, अब कोई जरूरत ही नहीं.
बस इंस्ट्रक्शन
कोई जरूरत ही नहीं है. हम इनको ऐसे ही ऑर्डर करते हैं. उसके लिए कोई इंस्ट्रक्शन की जरूरत नहीं. और उसके बाद भी आपको चैलेंज करना को मन तो कोई जबरदस्ती आपके अकाउंट में थोड़ी ट्रांसफर कर देगा, राइट?
लीडरशिप so far as that compensation is part is वो अगर दे हम इंस्ट्रक्शन लिए लेकिन वो लोग
नहीं तैयार.
अभी
नहीं कोई बात नहीं, इट्स नॉट रिक्वायर्ड ना, दैट इज नॉट.
तो लीडरशिप ऑर्डर में बस लिखा दे हम लोग को समझा देंगे.
नहीं कुछ समझाने का जरूरत नहीं है. अगर वो भी लिखने की जरूरत नहीं है तो भी नहीं लिखा.
नहीं लीडरशिप कंपनसेशन दे दीजिए बिकॉज़ दे आर
WPL number 5938 of 2014. Heard the learned counsel appearing on behalf of the parties. And this writ petition has been filed for the following relief. The Learned Counsel for the terms of reference was as follows. Page 109 में थोड़ा mark portion है वहीं से terms of reference है. The Learned Counsel for the petitioner, by referring to the terms of reference, while placing the terms of reference, has submitted that the terms essentially was for deciding as to whether the Palandu, whether the management was justified in not giving work to the concerned workman in Palandu workshop and getting the work done by outside workers. The Learned Counsel has submitted that the court, while answering the reference, has gone beyond the terms of reference and has also tried to unsettle the matters which were already settled with regard to the closure of the establishment at Visakha. By giving the background, he has submitted that the petitioner had a separate establishment at Visakha in which there was a closure on, which was closed on 17/2/2023.
2003.
Sorry, 17/2/2003, and out of 41 employees, except 15 persons, rest had accepted the terminal benefits. The action of the management to close the establishment was challenged in writ petition being WPS number 2038 of 2003, which was disposed of by the Annexure 3, and the concerned authority was directed to consider the grievance and pass appropriate order, and ultimately an order dated 9/9/2009 was passed, holding that the closure was holding that the action of the management was not in violation of section 33 capital A of Industrial Disputes Act. And the closure of establishment was not amounting to change in service conditions of the employees. He submits that thereafter, in the year 2011, the dispute was raised and referred for adjudication, as the concerned workmen involved in this case were seeking to get accommodation in the another establishment, namely Palandu workshop, correct? And their grievance was that work was being taken from outsiders and they were not being accommodated in the workshop. The Learned Counsel has referred to paragraph 17 and has submitted that the authority has held that the authority has decided the case by referring to section 25N and 25F of the Industrial Disputes Act and has held that the Management's act of not continuing the services at Palandu workshop was illegal and unjustified. He has submitted that these workmen were never the employees at Palandu workshop. They were the employees at Birsa Chowk workshop establishment, which was closed. The Learned Counsel has also submitted that the concerned workman, employee hoga na? Workmen involved in this case have not has submitted that he has no objection if the concerned employee are still willing and ready to take the closure compensation which has been given to other similarly situated employees, if not already.
Closure compensation and full and final settlement.
Closure compensation
Gratuity
and
and all, everything.
Final settlement, including gratuity, etc. The Learned Counsel, appearing on behalf of the respondent, has opposed the prayer and has submitted that once the work was available in Palandu workshop, the concerned workmen ought to have been accommodated in that workshop. He has also submitted that the required procedure in terms of section 25N and 25F was not followed, and therefore the impugned order does not call for any interference. After hearing the Learned Counsel appearing on behalf of the parties, this court finds that the petitioner had two distinct establishments, one at Birsa Chowk and other at Palandu, and the impugned order reveals that they had different factory license.
Yes.
कहाँ है बताइए?
It's come in the evidence.
It further appears that it is further not in dispute that the concerned workmen were working at Birsa Chowk establishment, and on 17/2/2003 it was closed. The said establishment, the closure was challenged under such circumstances. A complaint was filed under section 33 capital A of Industrial Disputes Act, and the matter was pending before the conciliation officer, but no order was being passed. Consequently, a petition being WPS number 2038 of 2003 was filed by Ganon India's Shramik Sangh, and the said petition was disposed of by the order dated 23/7/2009, directing the Deputy Labour Commissioner, Government of Jharkhand, to consider and pass appropriate orders on the complaint filed by the petitioner under section 33 capital A of Industrial Disputes Act, if not already disposed of. As a sequel to the aforesaid, the Deputy Labour Commissioner passed order dated 9/9/2009, wherein it was held that the establishment was closed and therefore there was no change in the service condition, and consequently there was no violation of section 33 capital A of Industrial Disputes Act. The state order attained finality and the management had relied upon the state order before the learned labour court.
Exhibit A.
Which was Exhibit A.
It was Exhibit A.
Which was
You said
Exhibit
that the
A.
closure has never been held to be illegal by any.
And had asserted that the closure was never held to be illegal. And consequently, there was no violation of section 33 capital A of Industrial Disputes Act. It further appears that the concerned workmen insisted that they should be given work in the other workshop, that is Palandu workshop, which led to the apostate reference in the year 2011. So essentially the terms of reference was with regard to their grievance that they were not being given work in Palandu workshop and work was being given to outsiders. However, the learned labour court, while deciding the case, recorded the following finding, para 17. The learned labour, upon perusal of paragraph 17, it appears that the learned labour court was of the view that the concerned workmen that were discontinued in total violation of section 25 within bracket N and section 25 within bracket F of the Industrial Disputes Act. Although there was no such reference. Further, the learned labour court also recorded that all the workmen were employed on regular basis and were getting wages on monthly basis from time to time, and the management, the learned labour court also recorded that the management's act of not continuing the service as Palandu workshop establishment is illegal and unjustified. The learned labour court also observed that the employees who were working at Birsa Chalk establishment were not given service by the management in Palandu workshop, and that the Birsa Chalk establishment was not closure but it was shifting at Palandu establishment, and therefore directed that for natural justice the workmen must have been given employment in Palandu workshop. This court finds that the apostate findings which has been recorded by the learned labour court were beyond the terms of reference, and once it was held by the, and while coming to such a finding, the learned labour court has failed to consider the import of the order passed by the Deputy Labour Commissioner as dated 9/9/2009, wherein the state authority held that on account of closure of work, the state authority with respect to Birsa Chowk workmen held that on account of closure of work of the establishment, there was no change in the terms and in the service conditions, and there was no violation of section 33 capital A of Industrial Disputes Act. In view of the aforesaid findings, the impugned award is perverse and is beyond the terms of reference, and consequently the same is hereby set aside. However, it is observed that however, since the petitioner have themselves submitted that they are ready to give the closure compensation
Full and final settlement.
full and final settlement to the concerned workmen even today, it is sufficient to observe that needful be done by the petitioner at the earliest once one or the other concerned workmen approach them. This should be sufficient. This petition is accordingly allowed with the aforesaid observation.
Item 7, WC 4996 of 115.
In this case, one IA has been filed for granting time for the filing affidavit. There was a direction to file affidavit. Document note should not be procured.
ये जितने एफिडेविट्स यहाँ लगते हैं ये सुबह आके लगाते हैं, क्योंकि ये कोर्ट में नहीं जाते, हमारे पास नहीं जाते हैं ये एफिडेविट्स। IA number 13024 of 2024. The learned counsel for the parties are present. This interlocutory application has been filed seeking further 3 weeks' time to comply the order dated 21/10/24 and 14/11. By the respondent number, कौन file किया इसको? By the respondent number, district superintendent.
Yes.
By respondent number 3. What is the reason?
Reason that the certified copy of that order could not be reviewed.
Considering the aforesaid interlocutory application, the time to file the required affidavit is extended till 3rd of January. 3 तारीख January till 3rd of January. आगे is accordingly disposed of. ठीक है, और दूसरा केस क्या है, साथ में है?
Tag matter से.
नहीं, 3rd को नहीं जाएगा, एफिडेविट 3rd तक आएगा, उसके बाद इसके post on 29 January.
Item 9, WPC 3/666 of 2016.
This petition.
Last 86 time, being rejoined to our counter.
They have not filed it.
They have not filed it. We have not received it.
By way of last indulgence.
Matters pertaining to issuance of rent receipt and the document by which they claim their rights and title. Sada Hukumnama and earlier rent receipt, that is disputed by the state.
Disputed.
Our claim is it is declared at very inception 1948 a forest land. Thereafter, CS Khata also project that.
So there is a dispute in connection with right,
Yes,
title, interest,
absolutely.
and property.
Yes. And land is
क्या ही बोलना है?
Lordship, I pray for
By way of last indulgence बोला हुआ था ना?
So final disposal में कर दीजिए किसी
फाइनल डिस्पोजल ही कर रहे हैं ना? अननेसेसरी ये टाइटल डिस्प्यूट क्यों रेट पिटीशन में लेके आते हैं?
से कल रख दीजिए
आप ही हमको बताइए इस तरह के टाइटल डिस्प्यूट क्यों रेट पिटीशन में लेके आते हैं? एकदम टाइटल डिस्प्यूट है, वो बोलते हैं गलत है, सादा हुक्मनामा है,
नहीं रिटर्न भी हमारे नाम से हुआ है, रिटर्न भी हमारे नाम से। थोड़ा सा हम देख लेते हैं, एक जजमेंट हम लाना चाह रहे, कल रख दिया जाए इसको, कल रख दिया जाए, हम एक जजमेंट में लेते हैं।
आपका हुक्मनामा कब का है?
हुक्मनामा है 38 का।
अब पुराना सबसे पुराना रेंट रिसीट कब का है? जो आप लगाए हैं उसकी बात करिए।
रिटर्न हमारे नाम से 1950 में जो रिटर्न फाइल किया जमींदार, उसमें हमारा नाम है।
वो सबसे पुराना रेंट रिसीट कब का है?
देखो एनेक्चर 3 में
बताइए, डेट बताइए। ये सब डॉक्यूमेंट हम तो नहीं पढ़ पा रहे हैं, आप पढ़िए। जो डॉक्यूमेंट पढ़िएगा पूरा पढ़ाएंगे ऊपर से नीचे तक।
एक देखा जाए पेज 36 में 56 का है।
56 का है ना जी? मुश्किल है ना? आप ही बताइए, आपको हुक्मनामा से दे दिया तो आपके पास रेंट रिसीट होना चाहिए ना?
56 का है,
56
का।
और इस बीच 38 से 56 क्या हुआ? समझिए ना, गैप है, बहुत इंपॉर्टेंट गैप है, इसलिए ये सब ये टाइटल डिस्प्यूट आप जहाँ
It is also disputed.
दैट इज आल्सो डिस्प्यूटेड। कहाँ
इसको
से
कल रख दिया, हम एक दो जजमेंट और लेते आ रहे हैं।
जजमेंट से क्या होगा?
नहीं जजमेंट है, हम दिखाएंगे ना।
आप हमको ये दिखाइए कि रिट पिटीशन में टाइटल डिस्प्यूट।
नहीं हम टाइटल के लिए नहीं, हम नहीं बोल रहे हैं। आप जो सही बोल रहे हैं कि टाइटल डिस्प्यूट कैन नॉट बी एडजुडिकेटेड इन रिट जुरिसडिक्शन लॉ। I pray this is maybe taken up tomorrow, Lord, say I will ask this Lord.
Counsel further petitioner submits that the matter be posted tomorrow. Counsel further respondent submit that there is the documents which has been annexed by the petitioners in support of his claim are disputed by the respondents in the count affidavit, and such dispute may not be resolved under the jurisdiction. The petitioner may file title suit for declaration of right title interest in possession with respect to the property. Postmortem.
Item K, WPC 3840 of 2016.
We have challenged the order dated 28/7/2015 passed by the additional collector in mutation proceeding. So note the first apparent point is that note the additional collector have no jurisdiction under the statute to decide any proceeding relating to rent fixation under mutation proceedings.
Who filed this case before the additional collector?
The private respondent.
You are the private respondent.
I am appearing for the state.
So according to you,
Yes, ma'am.
this is the division, second division.
No, second.
They have assailed the
The
order of
petitioner's
appeal.
name was mutated. Note the private respondent filed an appeal before the additional collector, and the additional collector by the impugned order not set aside our Jamabandi and directed to create the Jamabandi in favor of the private respondent. This is a short.
Division is not
Yes.
maintainable.
Sorry, what? The revision is maintainable. But not the point is that in terms of section 14, the competent authority is circle officer, 15 notes LRDC, and 16 the revisional power is before the deputy commissioner. So additional collector.
Additional collector, it has been filed.
Additional collector. So not, my point is that without jurisdiction, the additional collector has no jurisdiction to decide this. So Lordship may see the impugned order itself, page 40 notes, annexure 4. The Lordship will find notes. Upper Sehmat.
What do you say? Jurisdiction का तो point ही नहीं उठाए आपने petition. Natural justice की बात करते हैं.
Natural justice हमको सुना नहीं गया था notes, लेकिन recently there have been judgments which says additional collector has no jurisdiction, and even the Lordship has also given a judgment.
वो तो हमको पता है ना मेरा judgment, लेकिन आपके एक line भी तो कहीं बोलते हैं.
But it is a point of jurisdiction notes which goes to the root. Although it has not been taken, but could.
कौन है private respondent?
Leadership, there was a previous order where time was taken by the petitioner for adding certain
No,
parties.
they have been added. They have been added, but notices have also been issued.
Notice was issued to 1A and 1A to 1E.
Yes, they are the private respondents.
They have appeared. Validly served. देखिए ऐसा है ना, जो पॉइंट आपने रिट में नहीं उठाया इस ग्राउंड पे हम नहीं सकते. हम इस ग्राउंड पे सेटिसाइड कर देंगे कि आपको नोटिस. अब जाके वहाँ अपना जुरिसडिक्शन पॉइंट दिखाओ. क्योंकि देखिए अभी तो रेस्पोंडेंट को इसी पॉइंट पे नोटिस गया कि नोटिस नहीं हुआ है, नेचुरल जस्टिस नहीं हुआ. अब जब वो नहीं अपीयर हो रहे हैं तब एक नया पॉइंट.
बट तब इसको इस पॉइंट पे सेटिसाइड कर दिया जाए कि हमको सुनवाई नहीं हुआ.
ठीक है, तो उस पॉइंट पे हम सेटिसाइड.
And with liberty to raise the point of jurisdiction.
All the whatever point you have.
Definitely.
Additional point जो भी हो आप अपना रेज करो.
ठीक. Yes.
That would be better ना.
Yes.
उनको जो बोलना होगा अपना बोलेंगे, आपको जो अपना जजमेंट दिखाना है दिखाना. जो पॉइंट आपने रेज नहीं किया उस ग्राउंड पे हम नहीं रेज.
ठीक है मतलब
आप बोल रहे हैं कि आपको नोटिस नहीं हुआ?
नहीं, हमको सुनवाई नहीं हुआ. आई एम सेइंग कि हमको सुनवाई नहीं हुआ, एंड आई हैव annexed the order sheet also to show. Yes.
बताइए, और impugned order कब पास हुआ?
But the final order has been passed.
25/7/15.
Yes, 25/7. The Lordship may kindly turn Lords to page 37.
37.
Yes.
Yes.
Lord 38 पे देखा जाए 11/11/2014 का ऑर्डर, जिसपे कि पुनः दोनों पक्षों को नोटिस निर्गत करें. Lord, on 11/11/2014 notices have been issued. Next date is 6/2/2015. And Lord, next date 6/2. आज अभिलेख उपस्थापित किया गया, उभय पक्ष उपस्थित हुए, प्रथम पक्ष द्वारा इस्तीफा दलील के प्रति दाखिल किया गया है, अतः अभिलेख सुनवाई हेतु 10/3 को रखें. 10/3/15. नेक्स्ट ऑर्डर, आज अभिलेख उपस्थापित, अध्यक्षाधिकारी अन्य कार्य में व्यस्त. 10/3. देन Lord, नेक्स्ट इज 14/4. अभिलेख उपस्थापित, अध्यक्षाधिकारी निर्वाचन कार्य में व्यस्त. देन Lord, 9/6. अभिलेख आज अभिलेख उपस्थापित, अध्यक्षाधिकारी अन्य कार्य में व्यस्त. देन 14/7. आज अभिलेख उपस्थापित, दोनों पक्षों द्वारा पूर्व में दाखिल किए गए लिखित बहस का वकालत का अवलोकन किया, चूंकि वाद बहस बहुत पुराना है, अतः आदेश है. बट ही इज नॉट हर्ड. दूसरे काल में व्यस्त है, पुराना है, इसलिए हम डिसाइड कर देते हैं, एंड देन ऑन द ऑर्डर इज पास्ड.
उसको भेज देते हैं वहीं.
It can be sent.
He will decide
Yes,
it
he will
afresh.
decide it afresh.
जो भी अपना jurisdiction का जो point है वहीं लीजिए. WTC number 3840 of 2016. Counsel for the petitioner and state are present. As per the office note, notice has been served upon respondent number 1A to 1E. But nobody has entered a clearance on their behalf. This petition has been filed for the following reason. The learned counsel for the petitioner, while assailing the interim order, has submitted that the order sheet, the previous order sheets have been enclosed, which reveal that the case has been decided only that there has been no hearing while deciding the case by the additional collector Dhanbad, and he has decided the case without giving opportunity of oral hearing. He has also submitted that he has additional point, though not taken in the petition, that the state authority did not have the necessary jurisdiction and the revision itself was not maintained. The learned counsel submits that the learned counsel has referred to the order right from order dated 11/11/2014, wherein both the parties wherein a direction was issued to issue notice to both the parties, and the matter was adjourned from time to time on account of non-availability of the concerned authority, and on each day the matter was posted for hearing, but on 14/7/2015, that is the date on which the order was passed, but on 14/7/2015, the authority has recorded that since the matter is an old one, the order will be passed on the basis of written submissions filed by both the parties. The learned counsel submits that such approach is not in accordance with law, and an opportunity of hearing ought to have been given to the petitioner, and even the point of jurisdiction could have been raised before the said authority during the course of hearing, referring to the provisions of law. The learned counsel appearing on behalf of the state has submitted that the matter be remanded back to the additional collector for fresh consideration, since no point of jurisdiction as such has been raised in the petition. The same may not be decided as the private respondents are not appearing before this court. After hearing the learned counsel appearing on behalf of the petitioner and the state, this court finds that the submissions made by the learned counsel for the petitioner that notices were directed to be issued to both the parties on 11/11/2014, and the day and subsequent dates were fixed for the purposes of hearing of the parties, but ultimately on 14/7/2015, the authority simply recorded that the final order be passed on the basis of the written submissions of both the parties, as the matter was old and has passed the impugned order. In the said order, even the appearance of the parties has not been recorded. This court is of the considered view that the impugned order has a bearing with regard to right, title, interest and possession. ये क्या चीज था?
Mutation.
With regard to mutation relating to immovable property and valuable rights of the parties are involved. In such circumstances, the matter having been posted for hearing on various dates, the same could not have been decided only by referring to written submissions without hearing the parties. Accordingly, the impugned order dated 28/7/2015 is hereby set aside and the matter is remitted back to the Additional Collector Dhanbad for granting an opportunity of hearing to the petitioner as well as to the private respondents hearing and pass appropriate order in accordance with law. It is further observed that it will be open to the parties to raise further points that may be relevant for the disposal of the case. This petition is accordingly disposed. The fresh order be passed without being prejudiced by the ordering.
Item 11, WPC 7513 of.
Here notes the challenge to an order mutation proceedings passed by additional collector. Annexure 1 here not jurisdiction point have been taken.
Okay. Where is the private respondent?
But there were notice notes.
Where is the private respondent? Yes, you are seeking time. Where is the private respondent? Notice was issued?
Yes, yes, notice is issued.
By which order?
But 2017 self-note notices were issued.
Respondent number 6 to 45. How many respondents are there?
Not 45.
Served properly.
But
jurisdiction point है
yes.
क्या बोलना है आप? एडिशनल कलेक्ट्रेट को है jurisdiction? डिवीजन किसके पास फाइल होगा? डेप्यूटी कमिश्नर या एडिशनल कलेक्टर? Who is the divisional authority? Yes, Act. Tenant holding one. Yes, please. ना साइलेंस से हम क्या समझें? नहीं पढ़े हैं भाई, इनको जरा ऑर्डर दीजिए दो चार.
Yes, but the first is without division benefit for 2003 to PLDR 431. This is Kapil Dev Singh's judgment note. Then your one judgment note has
इनको
been
दीजिए
passed.
ना, ये देखे नहीं, आप देखे नहीं है क्या? भी देख लीजिए. पास ओवर करिए, देख लीजिए सारे, पहला जजमेंट देख लीजिए, 2-4 जजमेंट
हाँ हम
हमारे
सब
भी
देते
हैं,
हैं मतलब 4
सब एक
जजमेंट
बार चारों दे दें।
हम सब देते
कि एपीलेट अथॉरिटी, रिविजनल अथॉरिटी इज अ डेप्यूटी कमिश्नर।
हैं। हम छोटा एक सिनॉप्सिस को वो भी दे देते हैं।
दे दीजिए। आइए 10-15 मिनट में जब भी देखें आगे।
Item 12, WBC 209 of 2018.
बताइए।
For the short synopsis notes, here notes the challenge is to.
There was an amendment. Amendment has been
Yes,
allowed.
there was an amendment, it was allowed, and amended writ was filed.
आप तैयार हैं ना?
नहीं काउंटर फाइल करना था इसमें अमेंडेड रीट का ऑर्डर।
क्यों नहीं फाइल करते हैं काउंटर? आप वेट कर रहे हैं कि हम इनसे सवाल पूछें खुद?
नहीं
फिर क्या चीज? Why have you not filed your counter?
2 weeks दे दिया था फाइल।
किनसे बातचीत आप कर रहे हैं? क्या मैटर है?
But sawmill का license have been cancelled on the ground that it was shifted.
सुप्रीम कोर्ट के ऑर्डर से कवर्ड है, क्या ही बोलना है?
हम इसे Lord, your lordship, may kindly see my list of dates. Short note, the point only we are raising is that notes in terms of the Bihar Sawmill Regulation Act 1990, this under section 5 there is a deeming clause that if your application is pending for more than 30 days, it is deemed approval. So that has been decided by the division bench. Your lordship will not put it in my mouth because my clients are. So not I have given that judgment also the reference. 2002.
Deeming clause has been struck.
Not this is the judgment.
So आप क्या करें?
I don't know case but since your lordship knows क्या.
काउंटर का ही चाहिए.
Page 690.
ये गोदावरी केस के बाद तो बहुत मुश्किल हो गया। मुश्किल मतलब ऐसे करना बहुत मुश्किल हो गया कि ऐसे 100 मिल कहीं भी खोल लीजिए, नहीं पॉसिबल।
एलिगेशन खाली ये था कि हम शिफ्ट कर दिए विदाउट परमिशन, although we have applied and we were harping on the deeming clause, but once I found that there is a judgment against me, it was my duty to point it.
We appreciate that. हाँ, impugned order दिखाइए।
Yes. Impugned order, initial order is annexure 9. Page 47, and the appellate order is annexure 8.
Annexure 9
and annexure 8. Appellate is annexure 8.
Initial order is
Page 47.
9. और appellate order is?
Appellate order is 2 page prior, not page 45.
Page 45. आपने एक रिट भी फाइल किया था पहले?
Yes, ma'am.
Appellate order में आपका क्या स्टैंड था दिखाइए?
But the show cause if you are
Yes,
annexure 4 is the show cause, and annexure 5 is my reply.
4 का पेज. हाँ,
Page 38.
Page 38.
Yes.
What was the allegation?
But the allegation was shifting of the sawmill to the actual place to a different place without permission, and running of sawmill there without having valid license.
Okay,
These were two allegations.
Shifting of sawmill
Yes.
without permission,
Yes.
and running the same at that place without license.
Without license. But in the show cause we have given that we have applied before the expiry of license for shifting, which was the application was pending. It has not been decided. Appellate order also notes that, and so far as renewal is concerned, we have said that we have applied for renewal also, but no renewal was granted, and we have applied within time along with the demand drafts and everything. Even that has not been returned.
Let us see the appellate one.
Yes.
Annexure 9. No,
Appellate is annexure 8, page 45.
Appellate.
Page 45. May I place this?
हाँ पर.
Yes. Heard both the parties, the learned advocate on behalf of Chamunda sawmill argued that because of excess pressure of the owner of the land where the sawmill was having license to operate, the owner of the sawmill had no option but to shift the sawmill to his own premises. The learned advocate also intimated that an application was submitted to DFO Ramgarh to allow shifting the sawmill to a place about 100 yards from the place of operation. At the same time, the applicant has submitted application along with demand draft for renewal of the license of the sawmill, but the application was not considered and still pending with the DFO Ramgarh. The DFO Ramgarh, defending the order of the licensing authority, said that the owner of the sawmill applied for transfer of the sawmill and without any permission to do so, the sawmill was in operation in different place for which no license is given. During inspection, the sawmill was in operation. Operating a sawmill in place for which no license is given is an illegal activity and violation of Sawmill Regulation Act 1990. After perusal of the recorded transpires
That's
that...
right. Go a bit back
Yes.
from the above. WPC number 209 of 2018 heard the learned counsel appearing on behalf of the parties. This petition has been filed for the following reason. The learned counsel for the petitioner has submitted that a show cause was issued to the petitioner dated 10/8/2016 within bracket annexure 4, wherein it was alleged that the petitioner had shifted the sawmill to a different location and without any prior permission, and was running the same in the said location without having any license. The learned counsel submits that the petitioner had filed an application for shifting and had also applied for renewal of license along with demand draft, but the same was not considered, and therefore there was no order was passed on the same, and therefore there was no illegality in the action of the petitioner. The learned counsel has also submitted that this aspect of the matter has not been properly considered by the Divisional Forest Officer Ramgarh and also by the appellate authority who has passed the order, appellate authority, namely prescribed authority under Conservator of Forest, Territorial Circle, Bokaro. And therefore the impugned orders call for interference. The learned counsel for आपकी तरफ से लिखा है. The learned counsel for the respondents has submitted that the impugned orders are well-reasoned order, and there is no concept of deemed approval of renewal of license, and he has relied upon the judgment passed by this court in 2002 within bracket 3 bracket close JCR 690 JHR, and has submitted that the constitutional validity of deemed license.
But this is the Act 99.
Section 5. Paragraph in particular. The constitutional validity of proviso to section. Yes, the constitutional validity of Section 5 of Bihar Sawmill Regulation Act 1990, proviso to Section 5 has been considered, and the said proviso which provided that for a period of 30 days and thereafter, the period during which the application is pending for consideration, it shall be deemed as if the person was granted license under the Act and was operating the sawmill or the saw pit accordingly, has been declared to be otherwise. The learned counsel submits that unless the permission to shift was granted and a license was issued, the operation of the sawmill was not in accordance with law, and therefore the impugned order does not follow. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that it is not in dispute that the petitioner had shifted the sawmill and was running the same at the shifted place, and at the time he shifted and was running the sawmill, he was not in possession of license. The provision of deemed license as mentioned in the aforesaid Act has been declared to be ultra vires by this court in the aforesaid judgment cited by the respondents. This court has gone through the impugned order passed by the appellate authority, and this court has gone through the impugned orders and finds that the authority, particularly the appellate authority, has clearly recorded that the petitioner was running the sawmill without having the license. This court finds no illegality or perversity in the impugned orders, and accordingly, there being no merit in this petition, it is hereby dismissed. ये वाला जो जजमेंट है ना, इसका इसकी किताब ही मंगा लेंगे ना, ये वाला 690 कई सारे एक्ट में ये डीमिंग प्रोविजन है, ये आरआरडीए में भी वो तो है अभी एग्जिस्ट करता है,
एग्जिस्ट कर रहा है. But this was considered in light of the Forest Conservation Act.
हाँ नहीं
And then it has been
आरआरडीए में कि रजिस्टर्ड पोस्ट से जाना चाहिए और 30 दिन होना चाहिए. Lot of cases from RRD on this. हाँ क्या होगा देखिए. Who is the revisional authority?
Lordship, in this matter, the additional collector has passed the order not as a revisional authority but as an original jurisdiction. The original application has been filed before him and he has decided the.
Original application means the orders passed were not under challenge.
No order was challenged.
No order was challenged.
But this judgment is applicable in this case, Lordship. Even in the original jurisdiction, the CO is having power, Lordship.
Yes.
But the additional collector has no jurisdiction itself. Not even original appellate, कुछ भी नहीं. And it has been held, Lord.
कहाँ है बताइए order?
Yes.
Page 21, Lordship, Annex 1.
आवेदकों ने application was filed.
Yes, application was filed.
Application was filed. ये ऐसा नहीं है कि बिना application के हुआ.
Application was filed.
And then
और petitioners के नाम पे जमाबंदी चल रहा था. Private respondent filed an application before additional collector. Additional collector और petitioner का जमाबंदी cancel करके private respondent का नाम से open करने के लिए order कर.
भाई अगर जमाबंदी कहीं से खुला है तो वहीं पे न चैलेंज होगा या उस ऑर्डर के अगेंस्ट में अपील फाइल होगा.
But Should I pass on?
और ये तो अगर मान लीजिए कोई भी जमाबंदी क्रिएशन से जमाबंदी तो क्रिएट हुआ हुआ बाय एन ऑर्डर मस्ट बी देयर. Is there any order for creation of jamabandi?
Good.
Any order passed by any other authority?
So far as petitioner is concerned.
Yes.
No, but we have mentioned it in, but there is no order annexed to this.
Lordship, in page number 23, it is mentioned आवेदकों ने विगत सर्वे खतियान की छाया प्रति दाखिल किया जबकि विपक्षी द्वारा ग्राम जमुनिया डी का दिनांक 30/8/56 को निर्गत मालगुजारी रसीद दाखिल किया है जिस पर खाता प्लॉट एवं रकबा दर्ज नहीं है और न इसका ग्राम डेमुगाड़ा से कोई संबंधी है. विपक्षी ने जमुनिया डी एवं डेमुगाड़ा का संयुक्त मालगुजारी रसीद वर्ष 2016-17 का दाखिल किया है जिसमें प्लॉट एवं प्लॉट वारी रकबा दर्ज नहीं है. विगत सर्वे खतियान के अवलोकन से स्पष्ट होता है कि खाता संख्या नंबर 14, 15 एवं 16 विगत सर्वे खतियान में देवलोहा, असगर मियाँ, छक्कू तेली, सनीचर तेली, अफसर मियाँ, बीगन लोहार, चुनन लोहार एवं भद्रू साई के नाम से दर्ज है. हल्का कर्मचारी द्वारा खतियानी रैयतों की वंशावली दी गई है. विपक्षी ने खतियानी रैयतों द्वारा भूमि का इस्तीफा दिया जाने की तथा इस्तीफा की उपायुक्त द्वारा अनुमति दिए जाने.
But page 24 bottom paragraph के लॉर्डशिप में सी अतः अंचल अधिकारी द्वारा समर्पित जांच प्रतिवेदन और विपक्षी द्वारा अपने दावे का ठोस प्रमाण प्रस्तुत नहीं किए जाने के आलोक में ग्राम स्वयं खाता इतना कि वो भी विपक्षीगण के नाम से चल रही जमाबंदी. तो हम लोग के नाम से जो चल रहा था जमाबंदी वो रद्द की जाती है. अंचल अधिकारी श्री को निर्देश दिया जाता है कि वे आवेदक जो खतियानी रैयत के उत्तराधिकारी हैं उनके नाम से नियमानुसार जमाबंदी कायम करें. सो पिटिशनर का जमाबंदी कैंसिल कर दिए विच वाज ऑलरेडी रनिंग एंड टू क्रिएट अ जमाबंदी.
आपके नाम से तो कोई जमाबंदी का ऑर्डर हुआ होगा ना?
हाँ हुआ होगा. इसीलिए तो तभी तो मेरा नाम से चल रहा जमाबंदी को कैंसिल किया. Which mentions कि हाँ चल रहा जमाबंदी.
आपने काउंटर फाइल किया है?
काउंटर फाइल
इसमें कहीं लिखे हैं किसी के नाम से जमाबंदी चल रहा था? Yes.
We have specifically stated in para 7 and that has not been denied in the counter. We have said so, my lord, that we have been granted settlement after vesting also. Jamabandi has been opened in the name of ancestor of the petitioner and up to date rent receipt have also been issued and the petitioners are in possession of the land.
Who's for the private respondent?
प्राइवेट रिस्पोंडेंट्स नोटिस तो हुआ था, वैलिड
They're
भी
not
हो गया। इसी में सिमिलरली दूसरे का भी रिट पिटीशन था। दिस इज 43 पलामू वाद संख्या 43 विधि वाद संख्या, यहाँ 44 है। दैट हैज बीन डिसाइडेड। सेम एडिशनल कलेक्टर का इम्प्यूग्ड ऑर्डर वाज क्वॉश्ड ऑन द ग्राउंड ऑफ
इसमें
जुरिसडिक्शन।
उनका jurisdiction का point आप इसमें भी नहीं है।
नहीं अरविंद वाल यस
कहाँ लिखा है?
पैराग्राफ 13 para 13
1
yes, which is beyond the jurisdiction of the additional collector. Oh, para 13, no, sorry, page 30, para 8.
ये तो आप ये बोल रहे हैं कि लॉन्ग स्टैंडिंग जमाबंदी नहीं कैंसिल कर सकते।
But we are saying that additional collector have no jurisdiction. But here
इसमें भी सेम ऑर्डर करेंगे। आपने ये भी लिया है ना इसमें पैरा 8 देखिए, आप लिखे हैं नो हियरिंग नो दिस दैट।
हाँ वो लिखे हैं नोट, लेकिन सिंस जुरिसडिक्शन का पॉइंट है,
जुरिसडिक्शन का पॉइंट देखिए बहुत तरह का बात है ना, लॉन्ग रनिंग जमाबंदी को कैंसिल करने का, लेकिन ये नहीं बोले कि द पिटीशन नॉट एट ऑल कुड हैव बीन फाइल्ड। डिविजनल जुरिसडिक्शन बहुत दूसरा तरह का जुरिसडिक्शन। नाउ ही फाइंड्स दैट देयर इज अ रिकॉर्डेड टेनेंट, देयर इज अ रेंट रिसीट रनिंग इन फेवर ऑफ समबडी, he calls for a report. We do not know parallel जमाबंदी जब जहाँ होगा, या मान लीजिए parallel claim जहाँ पर होगा with regard to rent receipt. If both the parties they produce conflicting rent receipt, तो उसको कौन resolve करेगा? उसको कोई तो resolve करेगा।
therefore there has to be an authority under the statute. The statute only
तो circle
authorizes.
officer कैसे इसको resolve
But
करेगा?
circle officer नहीं करेगा, not circle officer के order के ही basis पे दो parallel होगा।
नहीं ना है, बात ये है कि सर्कल ऑफिसर का ऑर्डर रहता ही कहाँ है पैरेलल जमाबंदी में। देयर इज ऑलरेडी अ जमाबंदी रनिंग जिसमें कोई ऑर्डर नहीं है, वो कोई हुक्मनामा से चल रहा है, ठीक है। उसी में एक और सर्कल ऑफिसर जो है एक दूसरे आदमी का भी जमाबंदी चलते रहता है साथ साथ।
So not once there is a dispute.
यही तो है, झारखंड में तो ऐसे ही चलता है ना। कहाँ है ऑर्डर सर्कल ऑफिसर का?
But I am only on this note that
नहीं देखिए, ये जो आपका पैरा 8 है ना, हम भेज देंगे वो सेम ऑर्डर करेंगे। नहीं करें, ऐसा नहीं करें। यस, सुपरिंटेंडेंट्स का इसको बहुत पावर है।
नहीं एडिशनल कलेक्टर को नहीं, ये दिस हैज बीन डिसाइडेड बिकॉज़ योर लॉर्डशिप
एडिशनल कलेक्टर को एडजुडिकेशन का पावर नहीं।
हाँ तो ही एडजुडिकेट्स हियर।
Therefore, वो किस तरह का पावर एक्सरसाइज करेंगे? ऐसा नहीं है इज एब्सोल्युटली पावरलेस, बट ही डज नॉट हैव एन एडजुडिकेटरी। अगर किसी जमीन पे वो देख रहे हैं कि भाई पैरेलल जमाबंदी चल रहा है, तो ही हैज टू पास सम ऑर्डर ऑन दैट। ही कैन नॉट शट हिज आईज कि हमको कोई पावर नहीं।
बट सिंस ही
आप ही बताइए, जो डिवीजन का पावर जो एडिशनल कलेक्टर वाला जो थोड़ा मोड़ा भी है,
बट डिवीजन का पावर तो है नहीं, इट हैज बीन डिसाइडेड।
नहीं एक सेकंड, एडिशनल कलेक्टर इज नॉट एन अथॉरिटी।
नॉट एन अथॉरिटी, इट इज ही इज नॉट एन अथॉरिटी। The only authority is circle officer, land reform deputy collector, LRDC section 15 appeal, and then the revision is before deputy commissioner. The word is under the act is it is collector of a district, and collector of the district has been defined, and there is a judgment also which says collector of a district will only mean additional deputy commissioner, not additional collector. So not additional collector has no jurisdiction itself.
He is not an authority under
Not an authority under that. Therefore, exactly this is my point. And I have judgments of division bench, your lordship's judgment, another coordinate bench judgment, and in this particular
तो फिर
case,
ऐसा क्यों बोला गया है कि उनको एडजुडिकेटरी रोल नहीं है? जहाँ तक हमको याद आ रहा है, he is nobody.
he is nobody. Your lordship may see that.
वो जजमेंट से दिख रहा है।
Section 14, 15, and 16.
Is the collector, that is the deputy commissioner.
Yes, the collector of a district. The word is collector of the district, and it has been defined as deputy commissioner, not
There is
additional.
one more provision which has been deleted.
Well, that was section 17. That was second revision. It was before the commissioner, but in 2002 there was an amendment and it has been deleted. Second revision before commissioner, after deputy commissioner has been deleted. But this is the division bench and the judgment passed by your lordship. and notes a coordinate bench, 2 coordinate bench on this. Good, sir.
So the authorities under the Act are
Circle of
14, 15 and 16.
14, 15, 16, correct.
So they ought to have moved at best before the
LRDC for cancellation, because since there is a Jamabandi,
or they ought to have moved before the circle officer.
circle of. So not additional collector at no given point of time.
Before the circle officer they could have moved,
They could
and
have
if the circle officer would have found something fishy, then he would have referred the matter
to LRDC.
ऐसा ही होता है ना?
Yes, LRDC. And then LRDC would have passed an order. Against that note, we would have referred him before Deputy Commissioner. So, this is what notes, short notes.
For the learned counsel appearing on behalf of the petitioner and the state. In spite of service of notice, nobody has appeared on behalf of the private respondents. The learned counsel for the petitioner has submitted that the private respondents had moved directly before the additional collector, stating that they are the legal heirs of the recorded tenant and a recorded tenant in connection with the property involved in the present case. And the learned additional collector, and they had a grievance in connection with running Jamabandi in favor of the petitioner. He submits that the additional collector has passed an order of cancellation of Jamabandi running in the name of the petitioner and has directed the circle officer to open the Jamabandi in the name of the legal heirs of the recorded tenant. The learned counsel has also submitted that the private respondent had also relied upon certain documents, including rent receipt. However, the additional collector is not an authority under the provisions of Bihar Tenants Holding Maintenance of Record Act 1970. And the proceeding itself was not made before the said authority. We have submitted that the relevant provisions are section 14, which deals with the requisition and disposal of mutation case, section 15, which deals with the appeal before the LRDC against the order LRDC, and section 16 deals with the power of revision of the collector of the district. We have submitted that it has been held by this court that the collector of district would be the deputy commissioner.
Deputy Commissioner.
And the additional collector has no jurisdiction. The learned counsel submits that in such circumstances, the exercise of power by the additional collector is wholly without jurisdiction. He submits that the private respondents could have moved before the circle officer and who would have verified the record and passed an appropriate order. And ultimately, the parties would have their right with regard to appeal or revision in accordance with the provisions of the Act of 1973. He submits that on this short point, the impugned order be set aside and it may be left open to the private respondents to take steps in accordance with it. The learned counsel appearing on behalf of the state has submitted that the power of revision has been exercised by the additional collector. However, he is not in a position to satisfy this court by referring to any provision of the aforesaid Act of 1973 that the additional collector has the power of revision under the Act of 1973. He has gone through the judgments which have been cited by the petitioner and is not in a position to distinguish the same. Correct? After hearing the learned counsels appearing on behalf of the parties and upon perusal of the provision of the aforesaid Act of 1973 and also the judgments passed by Patna High Court, by Honorable Patna High Court, reported in 2003, Supreme within bracket PAT, bracket rules 255, and followed by this court in 2018 to JCR 600. एक ही काफी है follow? This court finds that it has been held that revision, power of revision is vested with the collector of the district, who is the deputy commissioner. And additional collector does not have the power of revision. Rather, the power of revision which was conferred upon the additional collector by virtue of section 17.
No, not section 17 gives power to commissioner.
Commissioner, अच्छा ठीक है, इसको हटा दीजिए last. In view of the aforesaid facts and circumstances, this court also finds that the private respondent had filed an application directly before the additional collector, who has passed the impugned order by putting a nomenclature of miscellaneous case. This court is of the considered view that the impugned order passed by the additional collector is wholly without jurisdiction and cannot be sustained in the eyes of law, in as much as additional collector is not an authority under the provisions of aforesaid Act of 1973. On this technical ground, the impugned order has been set aside. Certainly, it will be open to the private respondent to agitate their grievance before the circle officer,
before the
to
competent
agitate
authority.
their grievance before the competent authority in accordance. ये वाला जो दूसरा केस किए थे 100 मिल वाला उसका है ये जजमेंट. ये जजमेंट्स रख लेते हैं. ऑर्डर्स करते समय थोड़ा सा करेक्शन करने में इजी होता है. कभी कभी कुछ कोट कर देते हैं. This petition is accordingly dispatched.
Password case item 1 from supplementary list WPL filing number 12440 of 2024.
I responded. एक छोटा सा इनका डिफेक्ट है, right? He has said that it is petitioner बोलकर affidavit के is the partner of the petitioner. So that can be ignored. The defect ignored. आगे बताइए.
Thank you. Madam, in the instant case, order has been passed by APFC Jamshedpur, and the order is very arbitrary, one-sided, without considering the financial condition of the establishment.
Not required.
It is not required, but they have frised the account of the establishment.
Rightly so.
It's a running establishment. It is a contractor of the railways, so the entire business would get hampered if
We are not bothered about it. Railway will take care of it. What is your grievance over here? बस उतना ही भर में आएंगे. मेरिट में जाइएगा तो बहुत परेशानी में फंस जाइए.
ग्रीवांस मैडम ये है.
आपने वहाँ पे बोला कि it is for the same period.
It is for the same period.
इन्होंने बोला कि नहीं, it is for a different period.
मैडम
इसके बारे में आपको क्या बोलना है?
23/11/2013 से लेकर
23/11/2013 से लेकर
2023 तक के पीरियड के लिए इन्होंने पहले
डेट बताइए.
26/8/2013 से 18/7/2023. 26/8/2013 से 18/7/2023.
18/7/2023 में पहले ऑर्डर कर दिया. उसके बाद
इस
ये
ऑर्डर
कौन से पीरियड का है?
ये 26/8/2013 से 18/7/2023 के पीरियड का है.
नहीं,
हाँ.
कहाँ से बोल रहे हैं?
27 will clarify, madam.
Page number?
Yes, page 27. First, second, third, fourth and fifth para will clarify the dispute of period. Page 27. Annexure 6 to the writ petition.
बताइए, इसमें तो है 19/7/23 से 9/4/24 का पीरियड.
The earlier period is mentioned there in that the previous writ petition pertained to उसी में है जो
19/7.
Yes, just above that para, your lordship.
Yes, I've seen that.
26/8/13 to 18/7/23 was the period involved in the earlier WPL 7040.
बताइए.
मैडम ये जो पीरियड है वो पीरियड जो इन्होंने काउंट किया 26/8/2000.
पहले तो आपने अपना मेमो ऑफ अपील भी नहीं लगाया है यहाँ पर, तो हमें नहीं पता आपने क्या ग्राउंड दिया. आपने कोई स्टे पिटीशन नहीं फाइल किया है. आपने अपने पिटीशन में बोला भी नहीं है कि स्टे पिटीशन फाइल. आपने कोई वेवर का पिटीशन नहीं फाइल किया है. आपने बोला भी नहीं है कि वेवर का पिटीशन फाइल किया.
स्टे के लिए
कहाँ लिखे? स्टे पिटीशन फाइल किए हैं.
नहीं, इसी में
कहाँ लिखे?
लिखा है.
स्टे पिटीशन फाइल किए हैं. कहाँ लिखे?
मैडम प्रेयर पोर्शन में लिखा है.
प्रेयर पोर्शन में क्या लिखा? बताइए, कहाँ है आपका स्टे पिटीशन? आपका स्टे पिटीशन नहीं है, मेमो ऑफ अपील नहीं है. आपको यहाँ से स्टे चाहिए. बिना देखे एक तो स्टे ऑर्डर करते हैं, आप क्यों नहीं जाते उनके पास?
मैडम अपीलेट अथॉरिटी में हम लोग गए हैं, अपीलेट अथॉरिटी में वहाँ पर अभी कोई जज है नहीं।
आप गलत बोल रहे हैं, कल ही ऑर्डर पास किया, कहाँ है वो ऑर्डर पंकज जी? there is an additional charge of भुवनेश्वर।
भुवनेश्वर के एडिशनल चार्ज में डीके सिंह को अभी 26 तारीख से लाया गया है मैडम।
ठीक है, आप चले जाइए वहीं।
लेकिन उसके पहले इन लोगों ने तो फ्रिज कर दिया। हम लोग तो ये पहले से ही हम लोगों का केस वहाँ चल रहा था, उसी पीरियड के लिए इन्होंने फिर से 14B का नोटिस दे दिया और 14B के लिए पेनल्टी लगा दिया। एक पेनल्टी हम लोगों ने पहले ही उसको अपोज किया, वो हम लोगों ने चैलेंज किया उस पेनल्टी को हाईकोर्ट में चैलेंज हुई, हाईकोर्ट की उसमें ऑर्डर है 65 लाख हम लोगों ने पेमेंट।
that there is a appellate authority, maybe stopgap.
I'm sorry, madam.
There is an appellate authority.
Yes, charge court is there.
Charge court is there.
Earlier, the charge was with PO of Asansol. Now, since he is due to retire or perhaps retired, so
there has been gaps in between.
Few gaps, yes.
Few
But now
gaps
it
were
is
there.
they have notified additional.
They have notified it. Now he also says that let him approach him. 1 महीना के लिए करना।
Madam, one thing may I point out, madam, the period he is disputing, madam,
Yes. Period.
One thing only, I'll take
assume
1 minute.
everything.
No, I will take only 1 minute, madam, not on his conduct, madam. Madam, may I kindly say this, in my humble submission, this order ought to have been annexed by him. Though he has referred it, but not annexed it. The period of dispute time.
Madam, I have brought this order to be, this can be taken on record, this can be taken on record.
See page 2 of this order, the period in the earlier date petition.
It's an ex parte order. He did not submit any
This was also an
documents.
ex parte
He
order.
was disputing the period. Let it be. We are not here. अभी यहाँ पे कुछ pronounce कर देंगे तो क्या ही करेंगे वहाँ?
एक request था मैडम, in his own case for a different period there was a stay granted subject to deposit of part amount.
अच्छा एक बात बताइए, as per the provisions of Employees Provident Fund, he has got a right to apply for waiver of the entire deposit.
Yes, he can apply for waiver.
आप जरा बताइए
7
waiver,
waiver.
वो जरा EPF
7 reduce or waive.
Entire waiver is permitted.
आपने कहाँ लिखे हैं कि वेवर के लिए आप पिटीशन फाइल किए? स्टे पिटीशन नहीं होता है, या तो रिड्यूस होता है या वेव होता है।
वो हमने अपीलेट अथॉरिटी में फाइल किया।
कहाँ फाइल किए हैं बताइए ना।
यहाँ आपने लगाया है।
बताइए कहाँ लगा?
Annexure 8
बताइए।
Annexure 8 है। पिटीशन में Annexure 8 है।
पेज नंबर बताइए।
34.
क्या लिखे हैं आप इसमें?
अपील का सिर्फ रिसीट एक्नॉलेज।
सिर्फ अपील का रिसीट।
रिसीट।
तो क्या हम समझेंगे इससे? What should I understand out of this?
That an appeal has been filed at appellate authority.
Where is the petition for waiver?
Petition for waiver, it is mentioned in the appeal, madam.
कहाँ? कहाँ? अरे separate petition file होता है।
We were under the impression that on merit it will not be discussed here. It is only for stay. On merit.
यहाँ पे पोस्ट ऑफिस है हम लोग।
No, madam.
You think we are post office? यहाँ पे एक ये लगा देंगे और यहाँ पे हो जाएगा ऑर्डर। हम खोज रहे थे कहाँ है वेवर का पिटीशन भाई, और कहाँ लिखे हैं कि वेवर का पिटीशन फाइल की है? Have you even mentioned in your petition?
Yes, we have mentioned, but entire petition we have not fixed here.
बताइए, कहाँ बताइए? हमको तो नहीं दिखा, आप हमको बताइए, पढ़ के बताइए। That you have filed an application for waiver or stay, क्या ही फाइल की है?
Madam, Annexure 8 says an appeal was filed by the establishment in the Jurisdiction Tribunal CGIT 2 Dhanbad on 30th 9/2024 against the order of the Assistant PF Commissioner dated 17/9/2024. A request for early hearing was also made. The establishment contested the decision of the EPFO since the time the summon notice was served, and when the order dated 17/9/2024 was passed, the same was contested before the tribunal. For the same period, I mean the due date for both the summons are same. जैसे जनवरी में
समन कहाँ?
समन है, समन हम लोगों ने लगाया नहीं।
दोनों समन लगाए हैं?
दोनों समन है।
कहाँ है?
फाइल
अपने पास रखे रहिए।
हम फाइल कर देते
हाँ, तो
हैं.
आपको स्टे चाहिए, आप फाइल कर देते हैं, यही सब तो आपका चलता है.
Since petition would have become voluminous, that is why we have not filed it. And
आप हमारे वॉल्यूम की चिंता मत करिए, अपने केस की चिंता
ये दोनों हैं मैडम, देखिए.
एक महीना का इंटरव्यू रिलीज दे देते हैं. Don't disturb for 1 month. Let him go and look it. His entire conduct is absolutely not satisfactory. But still, जो अपील फाइल किए हैं, वेवर का पिटीशन किए हैं कि नहीं किए हैं नहीं पता, उसमें एक ऑर्डर कर देते हैं पास आके. Because now the appellate authority has become. एक महीना में क्या ही होने वाला है, ठीक है?
Status quo as on date, unfreezing of the.
No, we will just say that the impugned order of attachment will remain stayed for a period of 1 month.
Then they may say that you have to undo all action that you have.
Undo कैसे होगा?
Freezing.
अगर मान लीजिए आपने अगर पैसा डेबिट हो गया तो थोड़ी undo हो जाएगा.
उसको सिर्फ एक महीने में indicate.
If any amount has been debited, that will be subject to the result. You are for EPFO?
Yes.
Bank is not there.
No, bank is not for the bank, my lord, and the freezing, my lord, will continue till that time.
Freezing कैसे होगा? मतलब it will
For
remain
that amount.
stayed for that much of period.
So any further recovery will not be done.
काम बंद हो जाता है ना, समझ रहे हैं ना? The entire unit is stalled. अब इनके चलते तो क्या ही बोलेंगे, हमको बोलना नहीं चाहते.
Madam, I would like to draw your attention towards one decision of the Supreme Court in this regard, which says that in testing not industries, that until and unless the appellate tribunal has heard the establishment, coercive action should not be taken by EPF. That decision of the Supreme Court we have attached with this petition. May kindly go to page number
कौन सा
37.
ऑर्डर है इनका अटैचमेंट वाला? The bank.
Annexure 3. Annexure 3 with the petition. Madam, it is Annexure 3 with the petition.
देखिए, आपको हम इससे ज़्यादा कुछ नहीं बोल रहे क्योंकि आप पहली बार आते हैं.
Yes, ma'am.
लेकिन आपको ये चीज़ बताते हैं, आपका पूरा पिटीशन बहुत डिफेक्टिव और हमारे स्टैंडर्ड से तो बिल्कुल भी सही नहीं है. ठीक है, जब आप यहाँ पे इस तरह के स्टे पिटीशन फाइल करते हैं तो कम से कम ये भी होना चाहिए कि स्टे फाइल किए, वेवर के लिए फाइल किए, स्टेटमेंट तक नहीं है. लगाना तो दूर. Don't treat the court as a post office, but for the interest of the industry and एक महीना का आपको लिखिए.
एक छोटा सा रिक्वेस्ट है, अगर एक महीने में ये पिटीशन का हियरिंग में नहीं आ पाएगी,
एक्सटेंशन के लिए आ जाइएगा. एक ऑर्डर किए हैं हम.
till the time appeal is heard by the tribunal, ऐसा करके अगर दे दिया जाता, क्योंकि वैसा डिसीजन है सुप्रीम कोर्ट का, गुजरात हाई कोर्ट का भी डिसीजन है इस बारे में,
तो
और इनका अपना सर्कुलर भी है 2015
एक
का.
डिसीजन आपका रिजेक्ट करने का कर देते हैं, उसको लड़िए सुप्रीम कोर्ट. जितना वेवर का पिटीशन है, ना स्टे का पिटीशन है, ना कोई प्राइम फेसी केस बनाए कर दे. इसीलिए जितना देर नहीं होता है तो आप आ जाइए एक्सटेंशन के लिए, हम आपको एक्सटेंड. WPC number 12440 of 2024. Heard the learned counsel appearing on behalf of the parties. The counsel for the petitioners submits that the defect number 15 with regard to statement of vouching on behalf of others with regard to the affidavit may be ignored. The petitioner is the partner. The deponent is the partner of the petitioner. Even the wakalatnama has been executed under the stamp of the petitioner, which is a partnership. This petition has, and considering the aforesaid submission, the surviving, he has also submitted that the matter relates to freezing of the bank account, and the entire business of the petitioner has come to a grinding halt, and therefore the defect may be ignored. counsel for the respondent EPFO has no serious objection to the same, to the ignoring the defect. Accordingly, the surviving defect number 50 is ignored for the present. The case is taken up on merits and the parties have been heard. This writ petition has been filed for the following. The learned counsel for the petitioner has submitted that the petitioner has filed the statutory appeal before the appellate tribunal, being CG Central Government Industrial Tribunal number 2 at Dhanbad. But the said tribunal being non-functional, the petitioner has challenged the action taken by the respondents, by which the bank account of the petitioner has been freezed. The order freezing the bank account is dated 21/11/2014 as contained in Annexure 3 in the petition. The learned counsel submits that on the day that he has been informed that आपको है ना information भुवनेश्वर को मिला है judge?
Yes.
He has been informed that the presiding officer of Bhubaneswar CDIT has been given the additional charge at Dhanbad, but since he is not holding the court every day, therefore some interim relief be granted so that the petitioner may approach the said authority as and when he holds the court at Dhanbad and obtains appropriate relief. The learned counsel has also submitted that the petitioner is entitled to seek waiver of the deposit or reduction in the amount to be deposited. The learned counsel appearing on behalf of EPFO has submitted that in case any relief is granted to the petitioner, the amount which might have been already remitted cannot be directed to be given back to the petitioner, and such remittance should be made subject to the final result of the appeal before CGIT. After hearing the learned counsel appearing on behalf of the parties and considering the fact that after hearing the learned counsel appearing on behalf of the parties, this petition is disposed of with an observation that the tribunal having been made functional, though by making stopgap arrangement, the petitioner may approach the tribunal for seeking relief in connection with waiver or reduction so far as the amount of free deposit is concerned. The order of attachment of the bank account as contained in Annexure 3 shall remain stayed for a period of six weeks from today. In the meantime, it will be open to the petitioner to seek appropriate relief from the learned tribunal. It is observed that as and when the tribunal is available and if the petitioner moves the tribunal, appropriate order be passed in the matter regarding waiver of free deposit. it is further observed that if any amount has already been remitted to the Employees Provident Fund by the concerned bank in Canara Bank, Chakradarpur branch, West Singhbum, there is no question of giving the said amount to the petitioner by virtue of this order, and such remittance will certainly be subject to the result of the appeal pending before the learned tribunal. That's it. This petition is accordingly disclosed.
Appearance review. Password case item 4.
In this case, the petitioner who is mourning, his father has purchased one insurance policy, and during the period of insurance policy, he has been killed, he has been murdered. But see, there is no, he has no evidence, nothing is there. He has been murdered, that is taken place, that should be treated as an accident value, that in that context, the ratio has been decided.
That should be treated as accident.
Accident value, this ratio has been decided by the apex court.
In your favor.
Yes, that's why, my lord, in this case, Lordship, see, my lord,
Who is the murderer? Who is the accused in the case?
who has been already charge sheeted, my lord.
Who is charged? Is the petitioner charge sheeted?
No.
Who has been charged?
My lord, I'm just charged copy, I am not
But
in
not in case.
Yes, but I'm saying.
आप अपने पॉकेट में रखेंगे
ये
ठीक है ना?
उसका नाम जो है जिससे चार्जशीट हुआ उसका नाम है
बताइए कहाँ है जजमेंट?
अभियुक्त करना yes in this context earlier also argument has been advanced for this one portfolio and two judgment have been passed, two order have been passed by the subordinate by the coordinate bench. If lordship permit my lord, firstly my lord I am.
हम पढ़ के आए, आपको क्या लग रहा है? आप जजमेंट दिखाइए। सुप्रीम कोर्ट का जजमेंट दिखाइए ना?
ये सुमी देवी जजमेंट
आपने देख लिया है जजमेंट?
इस कॉपी मैंने दिया
नहीं मतलब क्या यहाँ ऑर्डर शीट में लिखा हुआ है तो आप एग्जामिन करेंगे आप बोलते हैं आपको पता ही नहीं।
यस इनको डायरेक्शन कौन बोल रहे हैं? सुनी कुमारी बोल रहे कौन? सुनी देवी। सुगिया देवी, हाँ सुगिया देवी, तो वही मैंने कहा उसी पर कोर्ट का व्यू था और सुगिया देवी को ही हम लिया थे। One more judgment by Lord, this is the National Council, National Consumer Dispute Center.
कंज्यूमर में जाना चाहिए था ना, रीट में क्यों आ गए?
It is not. I mean, this case.
आप बताइए अब रीट पिटीशन में किस लिए आ गए? नहीं जाना चाहिए था आपको कंज्यूमर, 2009 से यहाँ पेंडिंग पड़ा हुआ है। बताइए इसमें क्या लिखा है?
इसमें देखा, इसमें लोग दिखाना चाहते। अब फर्स्ट ऑफ ऑल क्या हुआ?
Where is the judgment that it has to be treated as a?
Yes, उधर इसी में मैंने जो आपको दिया है उसमें अगर एक जजमेंट अभी मैंने आपको दिया है उसको देख लीजिए। नेशनल कंज्यूमर ये जो है नेशनल काउंसिल का जजमेंट है जिसमें ये पहले यहाँ से इस पर रेफरेंस दिया गया है, हमने जजमेंट दिया था। सुप्रीम कोर्ट जजमेंट है पैराग्राफ 10 वही इधर कैन मर्डर बी एन एनिमल?
You see, ये कोई ले ऐसे जनरल लॉ नहीं ले डाउन किया है कि मर्डर विल बी ट्रीटेड एज एन
Yes, that we discussed.
तो उसके लिए तो फैक्ट्स देखना पड़ेगा ना, उसके लिए फैक्ट्स देखना पड़ेगा कि नहीं देखना पड़ेगा, आप इतना बताइए हमको।
ये नहीं कर सकते, टोटल डिस्कशन देखना पड़ेगा, लेकिन
तो
मेरा
फिर ये हम लोग रीट पिटीशन में क्या ही देखेंगे, एडमिटेड फैक्ट है क्या सब चीज़?
नहीं, ये एडमिटेड एफआईआर लगाए, एफआईआर भी हम लगाए हैं। एफआईआर में क्या है, एफआईआर में उस पार्टिकुलर डे में ये इनको बुलाया गया था एक पंचायत में, वो पंचायत से लौट रहे थे और रास्ते में क्या हुआ नहीं मालूम, इनको मालूम भी नहीं हुआ, घर वाले को।
इंश्योरेंस का डेट कब का है?
19 तक वैलिड था, 19 तक लगाया हुए नेक्स्ट वन देखिए।
कब तक ओरिजिनल इंश्योरेंस कब का है?
19 तक था, 2019 तक।
2019 मतलब 19 तक वैलिड था, लेकिन कब शुरू हुआ इंश्योरेंस?
नो
जनता पर्सनल एक्सीडेंट इंश्योरेंस पॉलिसी क्लेम
2006 से ही स्टार्ट हुआ, 2006 से।
तो 19 तक रिन्यू किया। डेट ऑफ एक्सीडेंट?
ये एक्सीडेंट हुआ 2006। डिवीजन में सुप्रीम कोर्ट का जो डिस्कस किया वो इस पॉइंट पर, मर्डर के पॉइंट पर, ये जरा सा देख लिया ये भी बहुत इंपॉर्टेंट जजमेंट है, कोर्ट में थोड़ा असिस्ट डिस्कशन हुआ डिवीजन पे सुप्रीम कोर्ट और डिप्टी वाद हुआ एन संतोष सेगड़े।
ये क्या चीज़?
इसमें वो मर्डर के सिलसिले में थोड़ा सा डिस्कस हुआ है।
तो ये क्या चीज़ हम देखेंगे?
ये जो इंश्योरेंस में इसको लाया गया था, नेशनल इंश्योरेंस का वो डिसीजन इसके लाइट में हुआ है, इसीलिए हम
कहाँ है डिसीजन दिखाएं, इनकी चिट्ठी दिखाइएगा। दिस इज अ लेटर।
हम उसको उसी के लाइट में दे रहे हैं जो डिस्कस हुआ था।
तो अभी हम दे दिए, जजमेंट तो हम दे दिए।
14 को देख लिया, पारा 14
ये तो देख लिए,
वही तो
पारा
वही
14
जजमेंट है,
देख लिया,
रीता
उसको
कुमार
डिस्कस किया गया है, पारा 14 देख लिया,
रीता देवी है,
ये जजमेंट है ना, ये तो देख लिया।
दे दी वही तो।
ठीक, उसको पारा 14 देख लिया, पारा 14 इसको डिस्कस किया गया।
पढ़ी तो रोड एक्सीडेंट से, इसमें भी रोड एक्सीडेंट हुआ है।
मर्डर है, हम सर
क्या चीज़ से मर्डर कर दी?
हम अपना साइटेशन दे रहे हैं, दिए हुए उसको देखने हैं, हम पढ़ रहे हैं जो हमने दिया है, जो नेशनल लोकल इनका सुप्रीम कोर्ट का जो डिस्कस किया गया सुगिया देवी वाला में, उसको हम रेफर कर, उसको रेफर किया गया था नेशनल कमिश्नर, वो हम पढ़
लंच के बाद।
हाँ, तो इस पर जब हम रेफरेंस पढ़ रहे हैं इसका,
एक सेकंड रुक जाइए। Is there any impediment in deciding this case in writ? Is there any dispute which you have created by filing?
Yes, Your Lordship, I filed the counter affidavit.
What is your dispute?
Yes, Your Lordship, that the annexure B may kindly be seen. That the exclusions of the annexure B, Your Lordship, page number 15.
Yes.
Exclusions, Your Lordship. Any existing disability, international self-injury or suicide, death or disablement under influence of liquor or drug, instead breach of law with criminal intention. And in this, Your Lordship, criminal intention is there, FIR is also there, and charge sheet is also submitted.
criminal intention.
So you are
It is
trying to
not-
make a distinction that if a person dies due to road accident,
This is not a road
this
accident.
is, suppose a person dies due to road accident due to rash and negligent driving, where basically intent is not there to kill, right?
There is no intent.
Then under such circumstances, the insurance coverage will.
Yes,
But whenever there is a murder,
yes,
which follows with a
criminal intent
intent, then under such circumstances,
is not.
But my lord, the
Very
discussion
specifically in the
murder
policy
matter.
itself.
तो ये जो मर्डर वाले केसेस में जितने भी ग्रांट किए हैं, वो किस सर्कमस्टांसेस में ग्रांट किए? दे आर अराइजिंग आउट ऑफ मोटर व्हीकल एक्सीडेंट्स। आर दे, you see para 10 जो है इस जजमेंट का, जो आप दिए हैं, पैरा 10, if the dominant intent of the act of felony is to kill any particular person, then such killing is not an accidental murder but is a murder simpliciter. While if the cause of murder or act of murder was originally not intended and the same was caused in furtherance of any felonious act, then such murder is an accidental murder. So you want to say that this is not a case of accidental murder?
Yes, sir.
Rather, it is a case coupled with intent to murder,
Yes.
and therefore
The insurance is not covered.
तो बड़ा मुश्किल है आपका इंश्योरेंस कंपनी, कोई मेरा मर्डर कर देगा तो आप हमको ले जाएंगे इंश्योरेंस? हाँ, बंद कर देंगे सारा प्रीमियम। ये अलग बात है कि जो मांग रहा है वही मर्डरर है, इसीलिए हम इनसे पूछे आप एक्यूज हैं क्या उसमें?
That's why I took charge sheet also. Just family.
क्या क्या आप लोग पॉलिसी चल कोई एक्सीडेंट के अलावा किसी केस में ऑर्डर हुआ है? आपके चार्जशीट जमा होने के बाद किसका कन्विक्शन हुआ?
तो इलाही नहीं।
कन्विक्शन तो हम नहीं किया।
क्यों नहीं? आपको कन्विक्शन से कोई मतलब नहीं।
चार्जशीट भी नहीं फाइल किया।
चार्जशीट तो लाए हैं हम, चार्जशीट तो मेरे पास है।
तो कन्विक्शन ट्रायल कंप्लीट हो गया होगा ना?
हाँ, कब का हो गया?
तो फिर आपने
कन्विक्शन तो हुआ ही होगा।
अब क्या अजम्पशन क्या पता 319 में आपको एक्यूज बना दिया हो?
देखना पड़ेगा, लेकिन मेरे पास जो हम आपको जानकारी नहीं वो कोर्ट को नहीं पहुंच सकते।
319 में आपको एक्यूज नहीं बना सकता है, क्या आपने सुपारी
लेकिन उसमें जो 302 का ही है और उसमें चार्जशीट से लड़ाई तो इसको हम
319 में आपको एक्यूज बना सकता है कि नहीं ये बताइए। तो कहाँ है कन्विक्शन? आप हमको कन्विक्शन ऑर्डर दिखाइए।
यहाँ तो फाइनली
कन्विक्शन ऑर्डर दिखाइए, केस का नंबर बताइए।
हाँ, केस का नंबर तो जीआर नंबर है मेरे पास।
बताइए जीआर नंबर।
35 of 2006।
2006 कौन से कोर्ट का है ये?
ये हुजूर एक के चांद सेशन जज गुमला का।
सेशंस जज।
चार्जशीट कब फाइल हुआ?
एसटी नंबर पड़ा हुआ था 278 2006।
एसटी नंबर कितना है?
278 2006 नहीं हुआ जजमेंट कौन बना भाई?
उसी समय वही होगा।
आपको क्या ये हमारे कंप्यूटर सिस्टम का एक्सेस नहीं है क्या? तो फिर क्या करते हैं आप? जरा इसका देखिए, इसका स्टेटस जरा देखिए। ये केस का स्टेटस देखिए।